Yes.
Lordship, I would like to mention item number 11.
Yes.
On behalf of Titapak, leading council is out of station, so matter may be listed after 4 weeks. And we have taken consent from Arhati,
On a request made on behalf of the petitioner, matter is adjourned to be listed when?
4 weeks.
No, give a date. We need required to give a date now.
Okay.
Today is what? Third.
Third.
1, 2, 3. We'll have it on 2nd of March. 2, 3.
Yes, Lordship.
2nd March. Yes.
My lord, I beg to mention one WPC number 572. This matter may be listed on tomorrow, my lord, because
Tomorrow
for hearing.
hearing by a mention memo. What is the urgency?
My lord, the matter is about the service matters, and the petitioner is on deputation, and deputation is about
List a matter for hearing by a mention memo.
tomorrow.
Come for
My
orders will consider whether it's right for hearing. Matter of which year?
25.
25. So how can you have it for hearing? They're old matters.
Tomorrow, my lord.
Not tomorrow. You could come for orders on Friday. We'll consider,
Yes, on Friday.
but not for hearing, for orders. Yes,
Yes.
next.
Lordship, I beg to mention item number 15, Lordship.
Yes,
And for the private respondent, Lordship.
yes.
I pray for further 1 week time to file affidavit in opposition, Lordship.
Response number?
4, Lordship, private respondent, Lordship.
Okay. On a request made on behalf of the response number 4, further time of 2 weeks is granted to enable filing of affidavit in opposition. List on on 18th of February. 18 to.
Obliged, Lordship.
Item number 1. Oh, yeah.
My apologies, my lord.
Yes.
My lord, though in the motion is this, but it's come for the third time today. In fact, on the first occasion, my lord, the Union of Government has short the time for my lord, instruction from the department, my lord. Otherwise, my lord, so far my projected cases, matter pertaining to the land compensation.
Land compensation.
Yes, but despite of that, I have a limited prayer before the lordship is that so far my grievances has been ventilated through the representation dated 18/3/2025, which is pending before the concerned authority. Therefore, I am here praying for direction to the respondent authority to dispose of the representation dated 18/3/2025. That I have a very, very limited prayer before the lordship.
For a direction for disposal of representation.
My lord, because they may,
Approach the court. Yes, what is it?
For that, Lordship, I have no objection, Lordship.
No. Why didn't you take the instructions? We are not required to give directions for, if there is a representation pending, either you reject it or accept it. Why should you direct? This is not the purpose.
Since Lordship, his prayer is for disposal of representation.
Is there any bar of disposal? You are directed to seek instructions. Tell us what have you done with the representation?
As per Lordship instruction, Lordship, it is under active consideration, Lordship.
When can you get back regarding the final outcome of the representation? Monday next.
Lordship, I need 2 weeks time. Lordship.
No, not 2 weeks. Matter was moved when? When was the matter?
was on 22nd December 2025.
20th of December 2026. You just need to take the instruction. What is the, hey, you have written instructions that is under active consideration.
No, Lordship.
Get it on Monday.
On Monday.
Hertz C. Modi Learned Counsel for the petitioner whose primary grievance is against non-consideration of a representation pertaining to acquisition of land. This court wide earlier orders. Where is earlier orders had directed the learned CGC to obtain instructions. Full stop. Sri, what is your name?
K. Loya, Lordship.
Your CGC.
Yes, Lordship.
Sri K. Loya learned CGC has submitted that certain instructions have been received that the matter is under consideration. Para, let concrete instructions be obtained and the matter be listed for motion on Monday next.
All
On which an endeavor would be made for disposal of the writ petition.
All right.
Deeply obliged.
Item number 2.
Yes.
May it please, Your Lordship. My lord, this is pertaining to proposed reserve forest. My lord, in the year 1977,
Hmm.
the preliminary notification under Section 5 of the Assam Forest Regulations 1891
Hmm.
and proclamation under Section 6 were issued. But thereafter, nothing has been done. No notice for inquiry claims and objections. And later on, after so many years, there was an attempt. The extra assistant commissioner,
Who are you, Mr. Patin?
I am one of the landowners of Malogam village. This Malogam area village covering about 8,600 hectares, where I also have the land, has been included in this proposed reserve forest plan. That has
That process which started in 77, that was not finalized.
not finalized.
Mr. Mawam,
My lord,
will issue notice at this
at this stage, yes, my lord, notice will
Third.
be issued.
T party learned counsel for the petitioner who is aggrieved by who has sought a direction to declare the process of constitution of a reserve forest which was initiated in the year 1977. Full stop. Yes, it is the case of the petitioner that the proclamation made under Section 6 of the Assam Forest Regulation 1891, which is applicable, has elapsed. Full stop. Let notice be issued, returnable on when? 2nd of March?
2nd of March.
2nd of March, Mr. Nabam?
If not, my lord, affidavit, at
2nd
least
March.
Second March, my lord.
written instruction also, my lord.
Three. R.H. Nabam, the learned AG, accepts notice on behalf of respondents,
All my lord,
all the respondents. Let extra copies be served upon him during the course of the day.
Obliged, Lordship.
Item number 3.
There's a caveat. Mr. Safu, you for the caveat?
Yes, ma'am.
Where is the caveat? Caveat. Heard 3P Tafu, learned counsel for the caveator who has lost this caveat with regard to an order dated 5/1/2026 passed by the Deputy Commissioner cum Chairman, Itanagar Planning Authority, Capital Region. First up, the caveator would be heard in the event this court proposes to pass any interim order. Sarah, caveat stands the charged. Yes, what is it?
My lord, in this writ petition, the petitioner is seeking limited and urgent relief. My lord, the prayer is that direction may be given to the respondent number 2 to dispose of the representation submitted by the petitioners and
Representation is with regard to what?
restoration of the approach road that completely damaged and blocked by the respondent number 3.
Approach road has been blocked.
Yes, damaged and blocked, which connect the residents of the petitioners. My problem is that my lord, the wife of the petitioner number 2, who is the pregnant, is stuck
Okay,
at the,
yes, government council, what do you say? How has the road been blocked? Is the projection correct?
The same case was, I mean, like that, taken up last time also. Now the respondent has come to file this petition.
Yes, what had happened earlier?
Earlier, he was this thing, respondent.
He was the respondent
Yes.
in a petition filed by Mr. Tafu.
Yes.
What was the outcome in that petition?
In that petition, the interim order has been passed. While
What is the interim order?
the land development permission which was given was cancelled by the deputy commissioner, we challenged that order, my lord. And this honorable court has stayed that order.
So, isn't there a class of interest?
Yes, my lord, that would be, my lord.
So, have you mentioned those facts here?
Yes, my lord.
Yes, and
So, we will have to have both the writ petitions together.
yes.
We
That
cannot-
Here, my, there's only restoration of the,
If the road forms a part of the land,
yes.
which is the subject matter of the earlier writ petition, will it be proper for us to pass an interim order? We can issue notice and get it tagged with the other writ petition. When it's-
Otherwise, my lord, he has the liberty because he is also a respondent there, my lord. But the petitioners.
You can file an application
Yeah.
for vacation of the stay order.
my lord, till that, because there is a pregnant woman and
Understood, but
School going
there
children.
cannot be there cannot be multiplicity of litigation. You have the avenue where a respondent there, you file an application for consideration, we'll
Yes,
consider it.
Yes. Otherwise, it is multiplicity, definitely, my lord.
There
Conflict.
cannot be two writ petitions. I think you are not on a right advice.
my lord, on that writ petition, they challenge the cancellation order.
But
But in my writ petition, only I am seeking the direction to dispose the representation.
So this petition, this prayer of yours cannot be raised in an IA. You can raise the in an IA in the writ petition.
My lord, it will take time, so.
No,
there is-
it'll take more time here. We'll have to issue notice, get the views of the other side. You have an urgency. When is that matter fixed?
Never, it was
For-
listed up 4 weeks more.
Date given.
Yes. But
Date-
date is not given.
When was notice issued?
Mother, notice was issued of
29.
29.
This 29.
Yes, yes, 29.
You file an IA. If you file an IA, the matter will be listed immediately. Okay? We'll have this pending. Or you file an IA, or we can do one thing. We can have this notice issued and tagged along with that.
Yes, ma'am.
In the
That will
meantime,
be better.
Yes.
it's up to you.
Yes.
We cannot say more than this. Okay? Your OMOD,
Yes, my lord.
heard Sri OMOD Learned Counsel for the petitioner who is praying for a direction for consideration of a representation dated 27/1/2026 for restoration of the approach road, which has been blocked by the respondent number 3. Full stop. Sarah? Pri P. Tafu, who is present for the respondent number 3 on the strength of a caveat, has however submitted that his client had earlier filed WPC number
26 of 2026.
26 of 2026, in which there is an interim order against the cancellation of
Land development permission.
against the cancellation of land development permission. Full stop. He has submitted that the present approach of the petitioner may not be the correct approach. Para, be that as it may, that notice be issued, returnable by 4 weeks. 3. So Learned State Council for 1 and 2, Mr. Ra- 1, 2.
1 and 2.
1 and 2,
Oh.
and 3 Pitafu, extra copies. List along with WPC 26 of 26. Fourth of pendency of this case shall not be a bar for consideration of the representation dated so and so, dated to have been filed.
Item number 4.
My lord, I'm appearing for the petitioner, my lord, in this matter. My lord, first of all, my lord, my apologies that I couldn't appear before my lord today in person because of prolonged.
Doesn't
illness
matter,
of my
doesn't
mother.
matter. This will come up or what?
Lordship, I have a prayer here, Lordship.
Oh, just a minute, I cannot see the council. Or not, or a little bit. Yes, can I have your name?
Abhinav Prakash, my lord.
Okay, Mr. Prakash, what is it?
This
Your
is
phone-
appointment of arbitration petition, my lord. It came.
Appointment.
Yes, my lord. Appointment, my lord.
Appointment petition pending since 2022. Why?
My lord, I don't know, my lord, because I appeared so many times in this matter before before this honorable court, but it couldn't be done, my lord. So,
Section 11 petition pending since 4 years. Why?
Lordship, actually, this respondent one, they had a standing council, Lordship. They have filed objection petition also. But then I was
No,
under the
is there,
impression-
are you, the aspect of having a dispute? Are you denying it?
Lordship, this respondent one have a objection saying that they have a delay of 6 years, Lordship.
6 years for?
In approaching this, Lordship, Honorable Court.
Delay from the date of the arising of the dispute.
Yes, Lordship. Lordship, actually, I needed some time today because this was handled by the standing council. Even the affidavit was filed by them.
Who's the standing council?
Earlier, Peter for Lordship, for housing department, Lordship.
Mr.
So,
Tafo?
I need to go through this.
No, he was there in the court. Where is he?
We have just gone out, Lordship.
His name is shown in the list. His name is there.
Lordship, yes. Even the affidavit is filed by them. So I was under
The section 11 petition is almost an administrative thing. We are not required to adjudicate anything. So why is it pending since 4 years? It's only for appointment of an arbitrator.
Understand, Lordship.
Please bring,
They have filed an objection petition, Lordship.
please bring Mr. Tafo. Mr. Prakash, we will have your matter after some time.
my lord.
Item number 5 to 8.
Made Peter Lord. My lord, I'm appearing item number 5, 6, and
5, 6,
and
8.
8. Yes.
It is no idea.
Huh?
It is no idea.
About
You for this whom? Private respondent?
private.
Yes, ma'am.
Yes. My lord, the matter relates to, it's a seniority dispute between promotee and direct recruit. I represent the promotee and my learned friend represents the direct recruits.
Yes.
My lord, just I'll give 3 dates, my lord. 24/11/1997. I'm placing the facts of item number 6, my lord.
We can take for disposal?
Yes. It's not a very long matter, my lord. Yes.
Which file?
My lord will kindly have the file of item number 6,
It will be 14.
WBC 14.
Okay, that is the main thing.
14 of 22, na?
I don't need I, 14 of 20.
My lord, 24/11/97, the petitioner number 1 was appointed as JE. He's a diploma holder. Otherwise, then present. Now graduate.
Petition number 1,
Petitioner number 1 was appointed on 24/11/97 as JE.
which department are you concerned? Public Works,
Hydropower.
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 Yes, madam. Petitioner number 2 and 3 were appointed on 17/12/97.
2N? 2N?
2 and 3, my lord.
Okay.
My lord, we have prepared a small.
Oh, yes,
list of-
that will be beneficial.
That will be beneficial. One for him. Yes. Now, my lord, will kindly have the rules, my lord, recruitment rules. That is at page number 56.
Yes.
On top,
How many petitioners are there?
three
petitions.
Miller.
Okay. Rules?
Recruitment to the post of assistant engineer rule 2005. Now, if your lordships would kindly come to page number 57.
Yes.
Column number 1, assistant engineer, and column number 5, selection post. It's a selection by merit. On right hand side.
Yes.
Miller. Then please come to column number 11. 50% by promotion and 50% by direct recruitment. Now please come to column number 12. By promotion from amongst the junior engineer of the department who have 8 years of regular service for diploma holders and 5 years of regular service for degree holder. So if one is a diploma holder, then
Understood.
well, acha. Petitioner who all are graduate. Yes. Now, my lord, all the 3 petitioners, they are degree holder, my lord. Therefore, by virtue of the rules, if your lordship would kindly
Reconcile this. This first at serial number, column number 5.
yes, my lord.
It says selection by merit.
Merit.
So there are 2 quotas. One is 50%. You'll
Direct
by promotion.
recruitment, 50% by promotion.
Yes, and for promotion you have laid down the criteria.
2 sub, yes, 12.
If you are a graduate,
Then the qualifying
5
service would be
if
5,
you are a diploma holder, then 8 years.
8 years.
Then is the selection a common selection? Cannot be a common selection.
No, it cannot be, my lord.
Hmm.
It cannot. No. As far as promotion is concerned, it's a common selection.
No, for the promotion, for the direct recruits,
For a direct recruit, it's APSC,
APSC.
or
Okay.
Public Service Commission.
Okay.
Yes. Now, my lord,
Almost same as Assam.
same, absolutely same. It's a basically a case how to, my lord, quota and rota, how to apply. That's the only thing, my lord. Government is in the session of matter at their instance, matter has been stalled. That's the case. Government wants to review the whole thing. Now, what had happened, my lord? Kindly see, going by the rules, on 12/8/2005, we have given the second date, my lord. Petitioner number 1 was promoted on officiating basis to the post of assistant engineer. In that list of date, my lord.
Yes.
Then 29/8/07, petitioner number 1, 2, and 3 were allowed to hold the charge of AE on officiating basis. Now, my lord, by this date, all the 3 petitioners became eligible. Now, we all know, my lord, what is a right to be considered for promotion. Now, in fact, my lord, in 2002 itself, all the 3 petitioners became eligible. Because they have completed their 5 years of qualifying service.
They are
They have,
degree holders.
yes, degree holders. And they have passed the accounts examination also. So they were eligible in 2002 December itself. And most pertinently, lordships will kindly take note.
Yes.
There were 3 direct recruitments in 2009, 2012, and 2015, when all the petitioners or the promotees were eligible for consideration, but for some reason or the other, my lord, DPC was not convened. As a result, my lord, serious prejudice has been caused, which fact has been acknowledged by the government itself now. Now, eventually, my lord, on 12/8/2005 and 29/8/2007, we were given officiating promotion, but we were drawing the salary of junior engineer. Thereafter, my lord, on 4/2/2009, against clear vacancies, petitioner number 1 and 2 were granted the pay scale of assistant engineer. Similarly, on 21/9/2010, petitioner number 3 was given the scale of assistant engineer with effect from 4/2/2009. In fact, all were given the scale with effect from 4/2/2009. Now, my lord will kindly take note of another important date. All the writ petitioner in the third case and respondent
This
in.
officiating arrangement was in view of the fact that no regular promotion exercise took place.
Yes. Now, my lord, my learned friend, Mr. Majumdar, my lord, he represents the clients who are direct recruits who were admittedly directly recruited in 2012.
Nine. 2009.
Huh? You said 14, 12, 14, 2002. बोला था ना? Okay, some of 2009 and some of them were 2012. Yes. Now, my lord, the issue which arises for consideration is who will rank senior? As far as facts are concerned, my lord, these are the relevant dates. Now, what happened, my lord, since our cases were not considered, then we instituted two writ petition, WPC number 574 of 16 and 36 of 2016. There our prayer was, my lord, that DPC should be constituted and to consider our case. Finally, my lord, pursuant to the order dated 16/1/2017, passed by coordinate bench of this honorable court, my lord, DPC was convened and the petitioners were substantively promoted as AE.
16/1 was the date of the DPC.
No, date of DPC was 31/10/19, my lord.
After the court.
16/1/17 was the court order.
Okay.
Yes. In WPC 574, then DPC was convened on 31/10/2019, and my lord, we were given the substantive appointment from 31/10/2019.
DPC was convened on 31/1.
10.
31/10. And from that date,
we have given seniority. So naturally, my lord, now we are down below.
you were given substantive appointment.
Yes, substantive
The post-
promotion rather.
Promotion to the post of AE.
Yes, yes. Post of AE. Well, in the meantime, some of us have become executive, assistant executive engineer also. That's a different issue. But basic dispute is this. Then, my lord, agreed by the decision of the government to give us seniority with effect from 31/10/2019, we filed representations, my lord. Several representations. Consequently, my lord, acknowledging our grievances, my lord, a subcommittee was constituted by the government by order dated 19/5/2020 to look into our grievances. Now, that is some importance in this case, my lord. So, I'd like to place that order. Please come to page number 94, my lord. Page 94. Minutes of the meeting of the subcommittee for determination of vacancy position for promotion as assistant engineer, hydropower development department under chairmanship of so and so. Now, if your lordship would kindly come to page number 95. Now, this subcommittee, my lord, takes note of the facts of the case, which is noted. Please come to the last paragraph. Accordingly, in the year 2005, requisition for 10 posts of assistant engineer were submitted to the Arunachal Pradesh Public Service Commission for conducting recruitment process in the year 2005. Again, in the year 2007, another 4 posts were sent to a PSC for conducting recruitment process, while later dated so and so. However, there were 17 posts which fell vacant against promotion and 16 posts which fell vacant against direct recruitment. So 3 posts again, promotion, 2 posts again were in hand as per the record. The process for direct recruitment took considerable time And commission recommended appointment of 4 posts in the year 2009 against the direct recruitment vacancy of 2007. In the meantime, department had appointed a few junior engineers as assistant engineer in the year 2005 against the above mentioned vacancies. So these officers are claiming regular promotion against the above mentioned 4 promotion vacancies. Recruitment rules to the post of assistant engineer provides that by promotion from amongst the junior engineer of department who have 8 years of regular service for diploma holders and 5 years of regular service for degree holder in the grade, provided that irrespective of seniority in the cadre of junior engineer, promotion to the post of assistant engineer shall be considered in order of seniority of completion of respective qualifying service. Thus, the degree holder or diploma holder who have completed their qualifying service earlier will be considered for promotion on the basis of completion of qualifying service. In the meantime, recruitment rule to the post of assistant engineer 2005 was subsequently amended in the year 2006, which classifies the post of assistant engineer as Arunachal Engineering Service Group A non-ministerial. It was further amended by inserting and passed in the accounts examination as junior engineer. And the third amendment provides that by promotion from among junior engineer of department who have rendered 8 years of regular service in the grade of junior engineer and passed the accounts examination as junior engineer. So the junior engineer who have completed 8 years of service shall come under the zone of consideration on or after 2008 to be considered for promotion to the post of junior engineer, assistant engineer. Now the persons are indicated. Now Milord will kindly come to page 99.
This rules of 2005,
Was amended twice, Milord.
no, it doesn't lay down how the seniority would be reckoned.
No, regarding seniority, there is nothing, Milord. Rule is silent on that. So therefore, Milord, general principles will apply. I'll come to that. Right from N.K. Chauhan and all these cases, Milord, including direct recruits case, the second proposition. Milord, it's a very interesting case, Milord, what I find yesterday while preparing the case. So the total post of page 99, Milord.
Yes.
Now this is how things are summarized. So the total post of assistant engineer is 48 and each line, that is promotion, will get 24 and direct recruit will get 24 each.
50%,
50%, Milord.
Yes.
Yes, sorry, Milord. As per the above statement, department have filled up 24 vacant posts of assistant engineer being officiating vacancies. The committee had been informed that the department had never conducted departmental promotion committee meeting and going on filling up the post of chief engineer, superintending engineer, executive engineer and assistant engineer on officiating basis only. Therefore, the claims and counterclaims had occurred. The above table had been filled up, leaving 50% post for the direct recruitment quota from 2005 to till date. Therefore, committee is of the opinion that appointing authority should dispose of the representation submitted by the promotees and direct recruits, if any, and finalize the relative seniority of direct recruit and promotees under 6, that is general principle of seniority. The relative seniority of direct recruits and promotees shall be determined according to rotation of vacancies between direct recruit and promotees, which shall be based on the quota of vacancies reserved for direct recruitment and promotion respectively in the recruitment rules. Since, Milord, recruitment rules is silent on how the seniority will be determined, therefore, according to the general principle, Milord, slot will go to the promotee, second slot to direct recruitment. Similarly, Milord, third, fourth, fifth, sixth, seventh, eighth. So promotee, in any case, Milord, it is well-known principle in the service law. If in a particular year there is a direct...
That stage has not arisen.
No, Milord.
If we have got the idea that after this, no, there is no progress.
Yes. No, now there is a progress.
Did they consider?
No, there is a progress which has been stalled by the direct recruits.
No, that is it. This process which was initiated by this minutes of meeting held on 23/6/2020.
Yes.
Giving an opinion that the representations of your
should be
clients,
disposed of.
their clients should be considered and disposed of.
Yes,
That process is not culminated.
that process is, my lord, midway through.
Okay.
Only because of the stay order obtained in the third case, that is stalled.
But this opinion or this view or the direction
Hmm.
was not only for you, it was for them.
For everybody. For everybody.
Why should
My
they
lord,
have to-
matter is very simple, my lord.
Now, what Mr. Chaudhary were proposing, how do you dispose of such a representation?
Huh.
Presently, perhaps it will not be prudent on our part to indicate. We will have to follow the law,
Law.
holding the field.
Yes.
Holding the field.
6 general principles of seniority.
And in that, both your case and their cases will have to be fairly considered.
Exactly. That is what we also want.
Why are you stalling?
My lord, if your lordship will kindly another 15 minutes time, my lord, I'll just place 2 case laws on this point.
Yes.
Factually, this is the case, my lord.
Just a minute, Mr. Chaudhary, just, yes, what is it that? the-
My lord, these representations have been disposed of. Lordship, if your lordship goes to the second writ petition,
Yes,
all this, pursuant to this,
yes.
writ petitions were considered and then the gradation list was prepared. That is at page
The
108.
second case.
You are agreed by the gradation list.
No,
we
they
are
are not. They are agreed.
No, Mr. Chaudhary says that it was not midway, then you have a stay.
No, my lord, in the second case, we have challenged the, my lord, gradation list. Now, the matter is very simple, my lord. If somebody has been promoted earlier in point of time, my lord, an argument which is sought to be advanced in their writ petition is, my lord, that in my humble submission is not correct. They would like to say that we have not entered into the cadre in accordance with the rules. I want to say that proposition is wrong. I'll place decision on this.
Okay, you can
Yes,
complete your
yes. Now, my lord, whole matter was before the Administrative Reforms Committee. Now, let us see, my lord, what the Administrative Reforms Committee has said. Please come to, my lord, page 116. Sorry, 115.
115.
Yes, my lord. It starts at page 111. But I'll have your lordship's kind attention to page 115, last para, towards the bottom of the page. 4th line, my lord. So the ratio, has your lordship's
Yes.
got it, my lord? So the ratio of promotion and direct recruitment in 24 posts is, as for the factual figures indicated in the detailed examination made above, the promotees has taken 27 posts and direct recruit 27. But out of the 27 direct recruits, the appointees of 2006, 10 in numbers, has already got promotion to the post of executive engineer from 2015 to 2018 on officiating basis. And serial number 1 and 2 of the promotee had got officiating promotion to executive engineer. However, promotees of the year 2005 and 7 are yet to be promoted to the executive engineer except Sri so-and-so and so-and-so. This irregularity may be due to the fact that their services were regularized from the date of DPC in the year 2019 instead of regularizing them from the date of their initial promotion, which it seems to be irregular as per the doctrine of continuous officiation enshrined under Article 309. It should not be Article 309 under the case laws, Miller. Of the irregularity is also due to not holding of the departmental promotion committee early and timely despite having DPC guideline as well as having vacancy of promotion. Out of the 29 promoters shown above, 4 candidates appear in 2005 and 7, and 2 of the candidates got promotion to the executive engineer. So remaining 27 stands filled up against promotion quota. So there is 3 excess appointment on promotion. Again, out of the 27 direct recruit quota, 10 candidates of 2006, a recruitment year has been promoted to the executive engineer during 2015 to 18. So 27 plus 14, 44 posts of assistant engineer were filled up. That is 27 against promotion and 17 against direct recruit. The remaining 4 vacancies shall have to be submitted to the APSC for conducting recruitment examination. In view of the above position, it appears that recommendation of the DPC for promotion of 17+7 to the post of assistant engineer is not proper. If recommendation of DPC is agreed and accepted, then seniority of the recommended officer for promotion has to be reckoned from the date of their initial promotion, that is 2005, 7 and 9. Otherwise, junior officers who were not in service during that period and appointed on a later date against direct recruit quota in the year 2009 will supersede the officers appointed on promotion during 2005, 7 and 9 respectively, which will have demoralizing effect on the senior officers. The roster system will also apply as indicated in the notes above by placing the officers recruited in the year as promotee 1, direct recruit 1, promotee 2, direct recruit 2 each, and the recruitment made in next year to be placed en bloc in the next recruitment year below the candidates of the earlier recruitment year. Say recruitment year 2006 will be placed en bloc below the recruitment year 2005. And recruitment year 2007 will place en bloc below recruitment year 2006 and so on and so forth. Now, what has happened is, Milord, we were given officiating promotion in Milord 2005 and 7. Eventually from 4 to 2009, we were, Milord, given regular scale of assistant engineer. Am I clear, Milord? And the direct recruits, they were appointed in 2009 and 12. As a promotee, Milord, we are bound to rank senior in 2009, then direct recruits. Now the issue is, in the impugned seniority list, Milord, we have been shown much below, which we have challenged in the second petition. I'll come to it little later. Now, what is the legal position in this regard? That's the only point, Milord. We were, admittedly, there were no DPC. Admittedly, in 2009, 2012 and 15, only direct recruitment took place. If promotion would have taken place, then Milord would have been above them. Now the question is, what would be the position of this officiating promotion, and we continuing continuously? That's the only point. Now Lordships will have the direct recruitment case, Milord. Hey, judgment lucky gola. Yes. First, Milord will have the direct recruitment case. Got case? 1992 SCC 715. 1990 SCC 715. Oghornath date uliya thabo question. Milord will kindly come to page 744, Milord. Para 47. Please come to Milord, proposition A and B and E. Once an incumbent is appointed to a post according to rule, his seniority has to be counted from the date of his appointment and not according to the date of his confirmation. The corollary of the above rule is that where initial appointment is only ad hoc, not according to the rules, made as a stopgap arrangement, officiating in such post cannot be taken into account for considering seniority. So in a given case, Milord, if the original appointment is ad hoc, not in accordance with law, then officiating in such a post will not confer seniority. Am I clear, Milord?
Yes.
Then please come to B. If the initial appointment is not made by following the procedure laid down by the rules, but the appointee continues in the post uninterruptedly till regularization of his service in accordance with rules, period of officiating service will be counted. My humble submission.
How do you reconcile A and B?
I'm coming. It was very difficult. Supreme Court has done it. I'll place that. Oghornath Day. As far as I understand, proposition A speaks of a situation where the initial appointment is in accordance with the rules. Therefore, naturally, my lord, from that date, seniority will be counted.
Confirmation will not be. consequence.
Confirmation is a glorious uncertainty, therefore it doesn't have any
But the initial appointment has to be in accordance with rules.
rules.
Yes.
Yes, that is one. We are not covered by one, we are covered by B, my lord.
Yes.
If initial appointment is not made by
No, the second part of A is.
my lord,
already-
corollary of the above rule,
Yes.
that therefore, my lord, if it is only officiating or ad hoc, not in accordance with rules, then continuous officiation will not confer any seniority from the date of the officiating promotion. But kindly see, my lord, in this corollary, that additional requirement of continuing uninterruptedly till regularization is absent. Have your lordships noticed that? But in B it is there. My lord, when I place Oghornath De's case, then it will be clear, my lord. If initial appointment is not made by following the procedure laid down by the rules, but the appointee continues in the post uninterruptedly till regularization of his service in accordance with the rule, period of officiating service will be counted. Now, my lord, just to understand, my lord, please have this 1993 3 SCC 371, State of West Bengal versus Oghornath De. Where precisely, my lord, this aspect was clarified. Please come to page 382. Para 21 and 25.
21 and
1 and 25. Precisely, this was the Millard issue. What is the meaning of A and B? Page 382.
Yes.
We shall now deal with conclusion A and B of the Constitution, benched in Maharashtra engineers quoted above. Now please come to 25. In our opinion, conclusion B was added to cover a different kind of situation
Yes.
wherein the appointments are otherwise regular,
Yes.
except for the deficiency of certain procedural requirement laid down by the rules.
This Maharashtra case is the direct.
Direct, yes, Miller. Yes. This is clear from the opening words of the conclusion B, namely, if initial appointment is not made by following the procedure laid down by the rules, and the later expression till regularization of his services in accordance with the rules, we read conclusion B, and it must be so read to reconcile with conclusion A. This is important. To cover the cases where initial appointment is made against existing vacancy, not limited to fixed period of time or purpose by the appointment order itself, and is made subject to the deficiency in the procedural requirement prescribed by the rules for adjudging the suitability of the appointees for the post being cured at the time of regularization, the appointee being eligible and qualified in every manner for a regular appointment on the date of initial appointment in such cases. Decision about the nature of appointment for determining whether it falls in this category has to be made on the basis of the terms of the initial appointment itself and the provision in the rules. Now, this is important. In such cases, the deficiency in the procedural requirement laid down by the rules has to be cured at the first available opportunity without any default of the employee. An appointee must continue in the post uninterruptedly till regularization of his service in accordance with the rule. In such cases, appointee is not to be blamed for the deficiency in the procedural requirement under the rules at the time of his initial appointment, and appointment not being limited to a fixed period of time is intended to be a regular appointment subject to remaining procedure requirement of the rules being fulfilled at the earliest. In such a case also, if there be any delay in curing the defects on account of any fault of the appointee would not get the full benefits. If there, for example, fault means supposing we do not qualify or certain other requirements will not come. The benefit being confined only the period which is not to blame. This category of case is different from those covered by corollary A in conclusion A, which relates to appointment only on ad hoc basis as a stopgap arrangement and not according to rule. It is therefore not correct to say that the present case can fall within the ambit of conclusion B, even though they are squarely covered by corollary in conclusion A. So in my humble understanding, my lord, subject to what your lordships may say, the corollary B, my lord, it is something like Umadevi. When Umadevi says or carved out a distinction between irregular and illegal appointment. So proposition A in my humble submission is something akin to, my lord. The second part of the proposition A is akin to what Umadevi has said, my lord. So therefore, in this case, we were eligible in 2005 and 7. Sorry, we were eligible in 2002 because we have completed 5 years, 97. We have passed the departmental exam. The duty of the department was to convene DPC. They did not do so. As a result, in 2009, 4 to 2009, we were given the regular scale. And our
Item 7, you are given the officiation.
officiating. But we are getting the salary of JE Miller. In 4 to 2009, we were given this regular pay scale of assistant engineer. And admittedly, the direct recruits are of 2009 and 2012. So if a DPC would have been convened in time, then my lord, we would have got the benefit. And these orders by no means are limited by any tenure or time. It is open-ended. Now, as per, my lord, proposition B, as explained in Ogornath Day, the duty of the employer is to cure the defect at the earliest. But they took long, my lord, 10 years. In 2019, they did it. So we continued uninterruptedly. So seniority is due to us. So therefore, now, my lord, no hyper-technical approach can be taken by the direct recruits to deny us our due benefit, which flows from Article 309 rules and the principles, general principle of 6 laid down by the central government. Now, my lord, this direct recruit case clinches the issue. Now, my lord, another judgment, N.K. Sohan. What is the significance of this continuous officiation, my lord? These are the code of the service jurisprudence matters. My lord, N.K. Chauhan is 1977, 1 SCC 308. Okay. 1977, 1 SCC 308. My lord will kindly come to page 323, my lord, paragraph 30.
30.
Yes. I'm placing the judgment for the proposition. What is the significance of, my lord? Continuous officiation in a scheme where, my lord, quota and rota applies, as in the present case. Here again, we are not disposed to hold, has your lordship got it, my lord? Having special regard to the recent decision of this court cited before us, that quota is so interlocked with rota that where former is expressly prescribed, later is impliedly inscribed. Kindly similar. Once there is a quota, then rota is, my lord, implied. Let us logicize a little. A quota necessarily postulates more than one source of recruitment. But does it demand the manner in which each source is to be provided for after recruitment, especially in matter of seniority? Cannot quota stand independently of rota? You may mix a quota for each category, but that fixes the entry. Quota methodology may itself take many forms, vacancy-wise, ratio, cadre composition-wise, proportion, period-wise, or number-wise, regulation, etc. Myriad ways can be conceived of. Rotational or roster system is commonly adopted, an easily understood method of figuring out the placement of officers on entry. Quota will enable, my lord, entry, but placement will be decided by rota. It is not the only mode in the code and cannot be read as an inevitable consequence. If that much is logical, then what has been done here is illegal. Of course, Sri Garg's criticism is that mere quota is not viable without provision for seniority, and if nothing more is found in the rule, quota itself must be understood to apply to each post as and when it falls to be filled. If exigencies of the administration demand quick posting in the vacancy and one source has gone dry for a while, then proper course is to wait for a direct recruit and give him notional date of entry as of the quota vacancy and manage to keep the wheels of the government moving through improvised promotion, expressly stripping such a haste of right flowing from the temporary occupancy. We have earlier dealt with the same submission in a slightly different form and rejected it. Nothing more remains to be said about it. What follows and matters on entry into service is seniority, which often settles the promotional destiny of the various branches of the incumbent. Naturally, the inter-se struggle turns how best to bend the rules to one's good account. Sri Garg criticized that what way is apparent in the argument backed by some ruling that quota being dealing from the rota, annual intake is the unit for adjusting the seniority among the candidates from two sources. This is an innovation. The rule, he says, we do not think so. So Supreme Court not accept it. Then please come to 32, my lord. We therefore reach the following conclusion. I'll invite your lordship's attention to 2. If any promotion has been made in excess of the quota set apart for the Mamlatdars after rules in 66 were made, direct recruits have a legitimate right to claim that the appointees in excess of the allocable ratio from among the Mamlatdars will have to be pushed down to later years, when their promotion can be regularized by being absorbed in their lawful quota for those years. To simplify by illustration, if 10 deputy collectors substantive vacancy exists in 67, but 8 promotees were appointed and 2 direct recruits alone were secured, there is clear transgression of the 50-50 rule. The redundancy of 3 hands from among the promotees cannot claim to be regularly appointed on permanent basis. For the timing they occupy the post, and only official grade that can be extended to them is to absorb them in subsequent vacancies allocable to the promotees. This will have to be worked out down the line wherever there has been excessive representation of promotees in the annual intake. Mr. Parikh, counsel for the appellant, has fairly considered this position. Now, this is very important. The quota rule does not inevitably invoke the application of the rota rule. The impact of this position is that if sufficient number of direct recruits have not been forthcoming in the years since 60 to fill in the ratio due to them, and those deficient vacancies have been filled up by promotees, the later direct recruits cannot claim deemed date of appointment for seniority in service with effect from time according to rota or turn the direct recruit vacancy arose. Now, this is important. Seniority will depend on the length of continuous officiating service and cannot be upset by late arrival from open market, save to the extent which any excess promotee have to be pushed down as indicated earlier. Here is a case, my lord, the direct recruits were benefited. Sorry, promotees were benefited. Direct recruits were at the receiving end. So Supreme Court says you apply the quota and rota and restore the position. So, my lord, for the first time in my humble understanding, subject to correction, my lord, this concept of officiating promotion for the purpose of determining seniority was acknowledged by the Honorable Apex Court. Prior to this, I don't find. There is one judgment in Patwardhan's case, there is some indication, but more authoritatively, my lord, this is where it has been laid down. My lord, there is another case from Tripura where exactly similar situation arose, my lord, that I will place. Tripura, my lord, Radha Mohan Malakar, 2009, 14 SCC 619. Yes. 2009, 14 SCC 619. My lord, to appreciate the facts, my lord may have paragraph 2, 3, and 4. At page 620. The dispute in this case is about relative seniority between direct recruit of 1990 and promotees of 1991 to the grade 2 of the Tripura Civil Service, which has been constituted on Tripura Service Rule 1967. The appellants in this case are direct recruit and respondents are promotees. The promotee filed a writ petition before the learned single judge of the Guwahati High Court, which was dismissed on 23/4/2004. But against the judgment in writ appeal, a writ appeal was filed by the promotees, which was allowed by the impugned judgment dated 5/4/2006 of the Division Bench of the High Court, hence the appeal. Now, kindly see, my lord, this rule 28(3) was the rule which fell for consideration in this case at para 4. The relative seniority of direct recruit and of promotees shall be determined according to rotation of vacancies between direct recruit and promotees, which shall be based on the quota of vacancy reserved for direct recruitment and promotion under Rule 5. So, more or less similar, my lord. Then, my lord will kindly come to paragraph.
There is a specific clause, how do you determine the seniority?
Yes, yes.
In the Tripura rule?
Yes, yes. But nevertheless, my lord, end of the day, lordships will find the principles which I am trying to submit for your lordship's kind consideration was accepted in this case. Now, please come to paragraph 6, my lord.
Yes, please.
At placidum G. The direct recruitment will occupy the vacancies, as your lordship's got it. This is what the division bench held, my lord, which was overturned by the Supreme Court. Direct recruits will occupy the vacancy within their quota, and the promotee who are occupying the vacancies within the quota of direct recruits will either be rewarded or absorbed in the vacancies within their quota. So also when direct recruit appointed in the vacancies which are within the quota of promotees after recruitment by promotion has taken place, the promotee will occupy the vacant posts within their quota. Then, my lord, will kindly come to next page, my lord. Subpara first. On a bare reading of the provisions of Rule 28 of the Tripura Civil Service Rule and the impugned instruction, it becomes apparent that impugned order dated is inconsistent with the and violative of the provisions of Rule 28. It is well settled provision of a statutory rule cannot be overridden or violated by administrative instruction, and that administrative instruction which is inconsistent with and violative of the rules is illegal and void. For the reasons stated above, we have no hesitation to hold that impugned order dated 28/5/91 being expressly inconsistent with or violative of the provisions of Rule 18 of the Tripura rule is illegal and void. Petition is therefore allowed and impugned notification is quashed. So this was the view of the division bench. Then my lord will kindly come to paragraph number 23, my lord. In our opinion, principle of decision in NK Chauhan can be illustrated by taking a hypothetical example. Supposing
23.
23, Miller,
Page has not come.
page number 627.
Page has not come.
Oh.
2 pages have not come.
It's just not yet.
625, 2 more pages are there.
There you go.
Doesn't matter. 2 pages have not
Huh?
come. If you have the copy, we can make.
Court's copy has come.
Just
2009-14 SCC 619.
page number.
Page number 619.
619. You can get the last 2 pages copied and have it clear. You can have the last 2 pages. Last 2 pages are not there. You can just have it from here.
Milord will kindly come to 627.
Yes.
In our opinion, the principle of decision in NK Chauhan's case can be illustrated by taking a.
You're reading 23.
Yes, Milord. In our opinion, the principle of the decision in NK Chauhan's case can be illustrated by taking a hypothetical example. Supposing in a particular service, 50% of the vacancies are to be filled up by promotion and 50% by direct recruitment. And suppose there is a rule that inter-se seniority of the direct recruit and promotee is to be fixed according to the rotation of vacancies between direct recruit and promotees in the manner that the first post will go to promotee and second to a direct recruit, third to promotee, fourth to direct, so on. Even here, the ordinary rule that seniority will depend on the length of continuous officiating service has to be followed unless quota of direct recruitment and promotees has been exceeded. So this is a Milord clear cut proposition, Milord.
In that case, is there any aspect of exceeding the quota?
Yes, then it has to be reversed.
No,
Milord, is,
in your case.
yes. Milord, I am not saying about promotee. Supposing if promotees are over, promotee quota is overutilized,
50%.
if that 50%, then reverse it. How can we stop that, Milord? What the direct recruits are trying to do, they are trying to stall that process. That way, Milord, they have no enforceable right. We are saying is, you should do it. It is only if the said quota is exceeded that appointees have to be pushed down in the seniority. Otherwise, seniority has to be taken from the date of continuous officiating service. In the present case, it is admitted that quota of direct recruit has not been exceeded. Hence, in our opinion, seniority of direct recruit has to be taken from the date of their initial appointment, and they cannot be pushed down in seniority. So same is the case here, Milord. Instead of direct recruit, we'll have to read as promotee. The promotees, so-and-so were appointed in grade 2 of the TCS after appointment of the direct recruit. Hence, former have to be treated as junior to the later. The earlier division bench decision of the High Court dated so-and-so has to be understood in the light of the decision of this court in NK Chauhan. The result of the impugned judgment of the division bench will be that 1990 direct recruits were recruited against vacancies created before 1988 will be pushed below 1991 promotee in seniority. In our opinion, this was the view of the division bench. In our opinion, such a view is clearly erroneous in law. In our opinion, government order dated 25/5/20 and office memorandum dated are valid and are in accordance with the Tripura Service Rule, and view of the division bench is not correct. So, Milord, this is a clear-cut case, Milord, where the principle of right of continuous officiation has been recognized. Milord, I'll place 2 more judgments, Milord. I'll place this NR Banerjee judgment for, my lord, the duty of preparing an annual, annual, my lord, list. This is also an added right as far as we are concerned. My lord, 1997, 9 SCC 287, Union of India versus NR Banerjee. If your lordships will kindly come to page 295.
Paragraphs?
Paragraph, my lord, 12, but I'll have your lordship's kind attention to page 295, placitum D and E. Now kindly see, my lord, just below the placitum D, the sentence starting with, empanelment is at best, has your lordship got it, my lord?
Yes.
A condition of eligibility for the purposes of appointment, and that by itself does not amount to selection or creation of a vested right to appointment unless relevant rules state to the contrary. However, in the light of the above principles and in the light of the clear rule extracted herein above, it is seen that exercise of preparation of panel is undertaken well in advance to fill up the clear vacancies or anticipated vacancies. The preparation and finalization of yearly panel, unless duly certified by the appointing authority that no vacancy would arise or no suitable candidates was available, is a mandatory requirement. So, my lord, preparation of yearly panel is a must. Otherwise, my lord, end of the day, my lord, we have a right to be considered. That right was denied to us. Otherwise, my lord, we have the qualifying service, we have passed the examinations. They did not hold the DPC, it was done later on. So we cannot be faulted, my lord. It's not on account of our fault. Itu kuntu? Maksudnya ki hal? Now, my lord, one judgment I'll place, that R.R. Verma's case, where administrative authorities, my lord, always have power of review. Otherwise, it will lead to chaos. 1980, 3 SCC 402. My lord will kindly have paragraph 5 at page 406. Now, that government has a power of review. For that proposition, I am placing this judgment.
Yes.
Page, my lord, 406, para 5. The last point raised by Sri Garg was that the central government had no power to review its earlier order, as the rules do not vest government with any such power. Sri Garg relied on certain decisions of this court in support of his submission, so and so, so and so, so and so. All the cases cited by Sri Garg are cases where government was exercising quasi-judicial power vested in them by statute. We do not think that the principle that power to review must be conferred by statute, either specifically or by necessary implication, is applicable to the decision purely of administrative nature. To extend the principle to pure administrative decision would indeed lead to untoward and startling result. Surely, a government must be free to alter its policy or its decision in administrative matter. If they are to carry out their daily administration, they cannot be hidebound by the rules and restrictions of judicial procedure, though of course they are bound to obey all statutory requirements and also observe the principles of natural justice where rights of the parties may be affected. Here again, we emphasize that if administrative decisions are reviewed, the decision taken of our review are subject to judicial review on all ground on which an administrative decision may be questioned in a court of law. So, my lord, principle is that if there is something wrong in an administrative decision, there's ample power for the, because it's an inherent, my lord. Otherwise, there will be chaos in the administration. Now, all that we are saying is, we were due for promotion. The authorities should have convened DPC. The authority never held the DPC, my lord. And my lord, as a result, my lord, our rights has been prejudiced. Now, finally, one last judgment, my lord, of the Supreme Court. My lord, 2008, 10 SCC 271. I should have placed the judgment before I place this, my lord. 2008, 10 SCC 271.
Name?
B.S. Mathur and another versus Union of India. It pertained to, my lord, Delhi Higher Judicial Services case.
This was, I think, referred to in a decision which you just quoted, I think.
Yes, it was referred, my lord. Now, if your lordships would kindly come to page 284, my lord.
What are the paragraphs?
Paragraphs are, my lord, I'll just give, my lord. For the facts, para 23, where the relevant rule is quoted at page 284. And, my lord, 40, 42 and 52. Please come to page 284, my lord. The inter-se seniority of the members of Delhi Judicial Service.
284 paragraph?
Top, my lord, para 8.
Yes.
The rule is quoted.
Yes.
The inter-se seniority of members of the Delhi Judicial Service promoted to the service shall be same as in Delhi Judicial Service. Seniority of the direct recruits vis-a-vis promotees shall be determined in order of rotation of vacancies between direct recruits and promotees based on the quota of the vacancies reserved for both categories by Rule 7. Providing that first vacancy will be filled up by direct recruitment and next two vacancies by promotees and so on. Here, my lord, rule was slightly different. Here, the first lot will go to the direct recruit. Now, my lord will kindly come to para 40. 40, yes. Para 40. Perusal of the seniority list drawn by the application of principles of rota and quota as laid down in Rule 8.2, read with Rule 7 of the rules, shows that in case the principle of rota quota is followed, then it would cause a serious injustice to the promotee officers inasmuch as direct recruit who have not yet entered the service without rank senior to the promotee officers promoted in their quota way back on so and so. If this is allowed to happen, this would not only be unreasonable but create a great heartburning among the officers appointed from the two sources. Hence, in our view, the principle of rota and quota contained in statutory rule read with so and so does not properly address the problem of resolving their inter-se seniority between direct recruit and promotee officers. Now, my lord, let us come to the facts of our case, my lord. When we were promoted in 2005 and 7 and given regular scale in 2009, it was on account of administrative exigency, my lord. Unlike this Delhi rules where it was said that first vacancy will go to direct recruit and the second will go to the promotee, that is not the position here. But Supreme Court was of the view, if we give a literal meaning to Rule 8.2, what would mean? That means a promotee was already in service, he will be junior to a direct recruit who may have come later on. So therefore, Honorable Supreme Court says that it cannot be applied. Now think in our case, my lord, please apply the same principle to our case. We came in the year 2009 and our quota says first you'll go to the promotee, second to the direct recruit. So where is the question of ranking senior to the direct recruits? Eventually, my lord, please come to para 42. There are other reasons in law why the principle contained in the said OM cannot be taken in aid for determining the interstate seniority officers of Delhi Higher Judicial Service. But before going into those reasons, it would be necessary to discuss the adverse consequence that would flow by application of the principle contained in the office memorandum. It is useful to refer, etc., etc. Now, eventually, please come to para 52. Here again, my lord, that principle of continuous official length of service was taken note of by the apex court. As observed earlier, perusal of the seniority list prepared on the basis of principle of continuous length of service clearly demonstrates that in case the seniority of officers of Delhi Higher Judicial Service is fixed by reference to their date of appointment, then nobody would suffer any injustice. Each and every officer would get due weightage of service rendered by him or her in the cadre of Delhi Higher Judicial Service. If interstate seniority is finally decided by applying the principle of continuous length of service, it may bring an end to litigation between the officers of the two groups. Therefore, principle of continuous length of service should be applied for determining the interstate seniority of the officers of the Delhi Higher Judicial Service appointed up to the year 2006. In case of officers appointed on the same date, whether the direct appointment or promotee, the seniority should be fixed on the principle as stated in OM dated so and so, since it cannot be determined on the basis of length of service alone in case of appointment from different sources of the same service. So, my lord, the common thread which runs through all the judgment or the preponderance of judicial view in my humble submission seems to be that continuous length of service. That is the safest way of determining seniority. If that is the position, my lord, where is the question of direct recruits who are not even born in the cadre will still a march over the promotees, my lord? That is against the very fundamentals of the service jurisprudence. Therefore, my lord, my humble submission is, as per the recommendation of the subcommittee, the government now is in session of our representations, and those representations should be allowed to be disposed of by laying down the principles of law as indicated by the Supreme Court, my lord. If there is an overutilization of promotee quota, then position of the direct recruits should be restored and vice versa. बाकी फाइल रुपा दिया रुका seniority. My lord, next is item number 8, my lord. Item number 8, my lord. 295/24. इन्हीं के साथ मारा को बड़ी ले जाना
Very common.
Yes. My lord, in this case, we have assailed the seniority list, which is at, my lord, page number 108. My lord, the seniority list starts at page 110, my lord.
Now is the seniority, is the memorandum.
No, my lord, 110.
110.
Yes. it starts at 108, my lord.
Yes,
Then the main final seniority list is at 110.
yes.
My lord, serial number 23, 24, 25, and 26. Their respondents number 2, 3, 4, 5.
Can you come again?
Yes, my lord.
20,
23 is R2,
R2,
24 is R3,
R3,
25 is R4, and 26 is R5.
yes,
Similarly, my lord, from 28 to 40, R6 to R18.
28 to 14,
40, my lord.
R, R6 to
R6 to R40.
14,
40, my lord.
no,
R18.
18.
Yes. Now, my lord will kindly see, my lord, at the page 110. For example, serial number 23, he became assistant engineer on 25/8/2009.
Yes.
Similarly, all are 25/8/29. The 2009. And my lord, if your lordship would kindly come to page 111, serial number 28 to serial number 40, they became assistant engineer in 12 and 15.
15, yes.
Yes. Whereas, my lord, if your lordship would kindly come to serial 44 is petitioner number 1.
44.
Yes.
Topinete.
Ete.
Tominete.
Yes, Tominete.
P1.
Vijay Pasang is P2. And serial 48, Swamso Tayang is P3. And we have been given, my lord, shown as if, my lord, we are a promotee of 2019. Whereas it should have been 4 to 2009. That means, my lord, the direct recruits were not member of service when I was in as a, that's why we have challenged.
How have they determined this 31?
My lord, they have what they did, my lord. Once the DPC was over on 30/10/2019, they said our seniority will reckon from 30/10/2019. 31.
So that principle which you had placed before this court, placed down by the Supreme Court in earlier cases,
not followed.
that officiating appointment, if it is on a continuous basis,
Yes.
and if the initial appointment was not a stopgap arrangement,
Yes.
those, according to you, have
Has
not been followed.
Yes. Then, my lord, let us come to the case filed by them, my lord. Now let us see, my lord, what is their right. End of the day, my lord.
By this challenge which you have made in the second writ petition,
Yes.
is there anything to be decided in the first writ petition?
Yes. My lord. No, my lord,
second
only
petition
when
has
they,
particular-
only when I succeed in establishing my point in the first petition, then only I'll succeed in the
No,
second.
the principles,
Yes.
principles, but the first writ
If that is held, it is automatically go.
on facts,
Yes.
they have acted and they have taken out a gradation list, which you are aggrieved.
Yes.
Now you said that this gradation list has not been done
In accordance with the rule.
following the rules.
Yes.
So
Then they'll have to redo the exercise.
Aspect of now presently asking them to complete the recommendation of the subcommittee, that would perhaps not be required, because they see, it seems that they have already acted, applied their men and come up with this, which is your challenge in the second writ petition. If you are successful in that,
Everything is, but my lord, what I understand is, my lord, going by the report of the Administrative Reforms Committee, which I have placed in page 116, I think government is moving in right direction, my lord. Anyway, I leave it to your lordship.
but this culmination,
That is subsequent to this, my lord. That's why they filed the third petition. That committee.
after this, there is another move. Oh, so there is a stay in that.
There is a stay in the third petition. Now, my lord will kindly come to the third petition, which they have filed. Etu kiman item? Eluka 284. Item number 5, my lord. My lord, I'll simply say this writ petition is wholly misconceived. They do not have any enforceable right. Because, my lord, we file a writ petition.
Just a minute, please. This is item number
5, my lord.
WPC
284 of 2024.
(284).
Yes, my lord. 284 of 25.
Mr. Mazumdar, you are in this petitioner?
Yes.
No, no, I'm not a petitioner.
Okay, Dicky. Which is your
Now-
petition, Mr. Mazumdar?
No, he's a respondent.
Respondent, my lord.
Now, my lord will just simply because I'm dealing the cases, that's why I'm dealing it together, my lord. That's why. Please come to me, lord. Page number 29, the prayer in the writ petition. Yes. A writ in the nature of certiorari should not be issued, quashing and setting aside the impugn order dated so-and-so passed by the Commissioner, Hydroelectric Department. Now that order is at, my lord, page number 226.
Two 26.
Yes, my lord. A committee is hereby constituted to examine the joint representation submitted by Vijay Pasing, that is petitioner number 2, Tommy Ete, petitioner number 1 in our case, and Swamso Tayang, petitioner number 3, concerning departmental promotion committee held for the promotion from post of junior engineer to assistant civil engineer civil dated 30/10/19, and fixation of seniority in compliance with the addendum order dated so-and-so. Committee shall examine the issues raised in the joint representation as contained in subcommittee report dated so-and-so and submit its recommendation accordingly. So, my lord, this was later in point of time. Perhaps government wanted to recall it, my lord. Now that has been stalled. Now, this writ petition was filed, my lord, and a stay was obtained on the ground that the principle laid down in Akaddas Ali's case has been ignored. In other words, if court is in session of a matter, then normally government should not, my lord, deal with the matter. But, my lord, they failed to notice the facts in Akaddas Ali's case. In Akaddas Ali's case, I'll
So
just...
this 35 was the subject matter of challenge.
Yes. My lord, hey, हमारे पास भी है. Now the stay order was given and their principal argument is, my lord, that Akaddas Ali's principle has been ignored. एक मिनट रुकना. Where is the interim order in this case? Pendency shall not be. वो कहाँ है? हाँ? There is an order, na? Where is my note? ये भगवान. कहाँ चला गया हो? Huh?
61 of what I,
In which case?
this is.
This matter?
Yes,
Page
61.
IA
Yes, I. It's
627. My lord, in this writ petition, my lord, we have filed an IA for vacation of that order. If your lordships would kindly have IA 217 of 25, my lord. 217.
Yes, we have.
Yes, please come to page 61. I'm trying to show, my lord, why principles in Akaddas Ali is not applicable. before I place Akaddas Ali judgment, at page 62, my lord, lordships will find the order while issuing notice in item number 6, that is item writ petition 14, which I argued, my lord. There, please.
Your IA is 217.
Yes, in that IA, please come to page 61. There is the order passed in, my lord, WPC 14.
Yes.
Please come to the last para.
But this is an earlier order.
Yeah, no, I'm just showing, my lord.
2022.
Yes, yes. All that I'm showing is, my lord, what is being done by the government has been permitted by this honorable court. That is why I say Akaddas Ali principle is not applicable. May I read it, my lord?
Pendency shall not be averred.
Yes. So our representations were pending.
Now, where is that order which was passed, or restraint order, page?
This one, my lord.
No, this is the order.
This is the order by which the government was permitted.
No, the restraint order passed in.
Oh, yes.
In the
That
IA?
order is here only.
IA, where have you?
Yes,
Next.
yes. Page 85.
It-
85, na?
27.6.
27.6, yes. At page 89. Page 89. Sorry, my lord, would your lordship should kindly come to page 88 for a moment. Mr. D. Panging, learned counsel for the petitioner, submits that since the issue is in session of this honorable court, no parallel proceedings could have been initiated, which is against the settled proposition of law laid down by this court in Akaddas Ali.
Yes.
Having regard to that, my lord, at page 89, having considered the submission of the learned counsels and considering that since the issue sought to be examined by a committee is pending before this court, in the interim it is provided that no final decision be taken in the event the company examines and submits a report without leave of the court. So, my lord, there the contention, basic contention in this writ petition is, first I have already submitted, my lord, a writ petition is filed to enforce a legal right. They have no legal right to stall the process, number one. Number two, my lord, application of Akaddas Ali is wrong. That I will now demonstrate presently. Why it is wrong? If your lordship should kindly come to Akaddas Ali's judgment, my lord. Para 4, 5, and 6, my lord. 4, 5, 6, and 7, small paragraphs. The facts in Akaddas Ali. Upon hearing the counsel for the writ petitioner, learned standing counsel cooperation department and respondent number 5 in the WPC, a learned single judge of this court by an order dated 1/11/2013, while issuing notice returnable in 6 weeks and posting the case on 16/12/13, directed that status quo as on date regarding holding of the office of the chairman of the society be maintained till the next date. So, my lord, there was a clear interim order of the learned single judge that on 1/11/13, that till the returnable date, that is 16/12/23, status quo regarding the office of chairman of the society shall be maintained. Now, what happened in this? Please come to para 5. It is relevant to note that submission was advanced on behalf of respondent number 5 in the said case that he was functioning as chairman. So on 1/11/2013, when the interim order of status quo was passed, even respondent number 5 also made a statement that he was functioning as a chairman. That is why status quo order. Now come to 6. While aforesaid writ petition was pending adjudication, Assistant Registrar of Cooperative Society passed an order dated 28/11/13, opining that writ petitioner in WPC, that is Mohammed So-and-so, was working as chairman and thus he be allowed to continue. So, my lord, actually, my lord, Akaddas Ali is not an authority, applicable in all cases. In the facts of this case, my lord, this order was held. And of course, as an incidental proposition of law, it was also said that normally when court is in session of a matter, then in such a scenario, the authority should not proceed on the same subject matter. No, lordships will permit them. The stay which has been obtained now, lordship will leave the stay and let government take a call. Number one. Or lordship decides the case on merit. Therefore, my humble submission is, my lord, it is not our case that if there is overutilization of promoting quota, direct recruits' positions should not be restored. Yes, their position should also be restored. If direct recruits have overutilized the quota, then promotees' rights should be restored. This is my humble submission, my lord. Therefore, in my humble submission, my lord, either lordships remits the matter to take this decision to logical end by laying down the principles of law, or lordship decides the case on merit. So this is my humble submission, my lord. And my final submission is, my lord, lordship will kindly grant me leave, permission to leave, my lord, because I have some
Leave to move. Move a petition.
I'm so obliged, my lord, for giving me this patient hearing.
Then what do you say?
Thanks. And he is eager. Lola. Pani bottle to move.
My lord, I also appear in writ petition, my lord, 459 of 2022, my lord, item number 7, my lord.
Initial writ petition of Mr. Chaudhary was WPC.
WPC, my lord. 14 of 2022 and 295.
No, the one which you are moving, the first one, which you moved today.
Item number 5.
Okay, where Justice Tagia had passed the interim initial order.
Yes, madam. Item 5.
Item 5 is WPC 14.
5. 14. Item 14. WBC number 14.
Item 6 perhaps.
Yes, madam. 6. 6. Yes. WBC 14 and 290.
Oh, your senior appears in item numbers 5, 6 and 8.
Yes, madam. Item number 5, there is a IA, my lord.
I is by the respondent.
No, my lord. Yes, madam. Community. Respondent in 284.
That means you are basically in 6 and 8.
Yes, my lord.
Not 5. 5 you are respondent.
Respondent, madam. 14 and writ petition number 14 and this one, my lord. 295.
295 or 20?
2025, madam. 2024.
Okay. Okay. So, Sakya, you're for whom?
My lord, I am for, my lord, writ petition 459 of 2022, item number 7, my lord.
Similarly placed.
Similarly placed, my lord. Only my dates are different, my lord. And also in item 5, in IA,
Just a minute. You are in item 5.
in item 5, my lord, I file an IA, my lord.
No, you are which petition? You are a petitioner.
No, main writ petition is, my lord.
You have filed a writ petition.
Yes, my lord. 459 of 2022.
459
of 2022.
How many petitioners?
Dharma Ete and one another, my lord. He is
one petitioner.
One petitioner. 2 petitioners are there, my lord. One is retired, my lord.
And you are also an applicant in the IA,
IA, my lord, for
item number 5.
5, my lord,
For
for
vacating.
vacation of the interim order, my lord.
IA number
IA, my lord, 207 of 2025, my lord.
207 of 25 in WPC
284, 2025, my lord.
for vacation.
Vacation, my lord.
Okay.
Well, in read petitions, my lord, I will subscribe and adopt the arguments of the my lord, senior counsel, my lord. Only dates, my lord, and I will place only one judgment, my lord, regarding my lord continuous officiating promotion and the my lord review power of the review.
Have a
My lord.
sit. Sit down.
I was initially appointed, my lord. I have not given the list of it, my lord.
Doesn't matter.
So, initially appointed on my lord, as a junior engineer on 24/11/1997, my lord, and was given, my lord, of
You are a degree holder or a or a diploma?
I am degree holder, my lord.
Degree holder.
And my lord, I was given, my lord, officiating, my lord, assistant engineer as a functional basis on 2/7/2007, my lord. And subsequently, my lord,
As A with the with the pay of G.
G, my lord. And my lord, by an order dated, my lord, 4/2/2029, my lord, or 2009, 4/2/2009,
You have
I
given
was
K
given
scale of
officiating promotion with scale, my lord, and all the financial benefits, my lord. Thereafter, my lord, I filed several representations, my lord, for consideration of my regularization, my lord, to the post of assistant engineer. Finally, I filed a writ petition, my lord, on writ petition, my lord, 574 of 2016, my lord.
16.
16, my lord. By an order dated 16/1/2017, my lord, has directed the authority to identify the vacancy position, my lord, and vacancy position, my lord, of the promotional quota,
Yes.
and to consider my case by a DPC, my lord. This was, my lord, my writ petition was disposed of, my lord, by a committee, my lord. My lord, kindly for a moment, my lord, see the report of the committee, my lord. Page number 69, my lord.
You are on the. We need 459. 459. This also.
459 of 2022.
Page 69.
69, my lord. This is the claim and objection, my lord. 11/4/2018, my lord. And the findings, my lord.
Just a minute, please. 69.
Page 69, my lord.
Yeah.
On exercise being done by the authority, my lord. Next page, my lord. In the middle of the page 70, my lord, report, my lord. May I read, my lord? The committee constituted by order number such and such dated 14/12/2017 made on several occasions and attempted to provide the view on mandate subject after examining all claim and objection of the assistant engineer is available in the file handed over to the committee, my lord. My lord, may I skip the my lord, second paragraph, third paragraph, my lord. Accordingly, a year-wise vacancy position has been calculated, which is placed at annexure 10, I will come to that, madam. Based on this available vacancies for direct and the promotion quota for the particular year, the eligible officers who have already been appointed as assistant engineer, their names have been filled against the vacancies based on direct, promote, and reserved roster point. It placed at annexer Y. I will come to that, madam. And the my lord, my representation, my lord, at page 71, my lord. My claim, my lord. Bottom, my lord. Claim and objection, and the right side, my lord, views, my lord.
Your client is Dharma Rete.
Dharma Rete, my lord. Claim number 2 kindly taken up, my lord. Claim number 2, my lord. Requesting the date of promotion as assistant engineer as on 2/7/2007 in accordance of the Guwahati High Court judgment, as he was given functional promotion with effect from 2/7/2017 against the clear resultant vacancy created due to such and such as executive engineer who have been given the pay scale of EE with retrospective effect. Because of this, vacancy occupied by me became a clear vacancy, and therefore I should be considered as a regular A. And the finding is, my lord, again, my lord, come to page, my lord, page 71, my lord, right side, my lord, column, right side, my lord. As per vacancy position in annexer 81, in annexer 10 in 2007, there
Not
is
10, this is annexure X.
annexer X, my lord. I come to that. There is already excess in promotion quota and no resultant vacancy thereby cannot be regularized with effect from date of visiting promotion as A, my lord. But from 2007, my lord, I cannot be considered, my lord. This is the findings, my lord. However, there are vacancies in 2008 subsequent to the creation of 5 more posts and promotion of Sri such and such with effect from such and such. Sri Dharma Rete, my lord, the petitioner, can be regularized with effect from 15/9/2008, my lord, against the reserve roster, my lord. Now, my lord, as identified in the vacancy position, my lord, kindly see, my lord, page, my lord, 84, my lord. This is the, my lord, page 84. Is the, my lord, exercise done by the committee, my lord. Roster, my lord, common roster, my lord. My name appears as serial number 4, my lord. Against the, my lord, promotion quota, reserve
Page
84, my lord.
84, where is your name?
Serial number 4, Dharma Rete, my lord. In roster, my lord, I fall in the promotional vacancy of my lord and a reserve vacancy of 2008, my lord. This has been identified, my lord. Thereafter, my lord, without adhering to this committee's, my lord, recommendation, my lord, the DPC was held, my lord, on 31/10/2019, my lord. Page 1112, my lord.
112.
Well, my lord. This is the minus of the DPC, my lord. Without considering the report of the committee, my lord. Second paragraph, my lord. The DPC examined the vacancy position, my lord. Immovable property.
This is DPC.
Yes, my DPC, my lord. A single page DPC, my lord. Vigilance clearance, integrity certificate of the officers in terms of recruitment rules established in the 2008. Recommended promotion regularization of the following officer with effect from date of DPC, that is 31/10/2019, my lord. My name appears as serial number 2, my lord. Serial number 1 is the other petitioner, my lord, who has retired, my lord. Showing that date
Dharma is actually petition number
2, my lord.
2. Gula was petition number 1. He retired.
2, he retired, my lord.
Yes.
Thereafter, my lord, we have again submitted representation, my lord. Then an addendum was issued by the state, my lord. Lords, you will find at page being agreed by the DPC, my lord. Page 124, my lord. Well, this 124, my lord. An addendum issued on 29/4/2020, my lord,
124.
by the commissioner, my lord, of the department, my lord. My lord has gone through this, my lord, document, my lord. The senior counsel has shown it, my lord. To review the, my lord, recommendation of the subcommittee, my lord. May I read, my lord? The government-wide such and dated 18/5/2020 has constituted subcommittee to consider the grievance of the officers who are promoted to the post of assistant engineer with effect from the date of DPC in its meeting dated 31/10/2019, and the seniority of officers were finalized on such and such dated 24/2/2020. Hence, the seniority position of the officers shall be reviewed based on the recommendation of the subcommittee and the approval thereof, my lord. Despite the, my lord, recommendation of the, my lord, subcommittee, my lord has already gone through the report of the subcommittee, my lord. That is the general principle of the seniority, my lord. The department has, my lord, published the, my lord, final seniority list, my lord. Wherein, my lord, my name is placed at, my lord, serial number, my lord, 42, my lord.
Page?
Page 135, my lord. Below the date, my lord, showing the date of, my lord,
No. When was this exercise done?
there is a memorandum, my lord, dated, my lord, 29/7/2022, my lord.
The list published.
Yes, my lord. Final seniority list, my lord. Below the, my lord, the direct recruitees of the, my lord, from serial number 23 onward, my lord.
Page?
Is 134.
135.
135. In 135, my name appears at, my lord, serial number 42, my lord. Showing the date of appointment as a assistant engineer 31/10/2019, which is the date on which the DPC held, my lord. And I was, my lord, placed below the, my lord, the direct recruits of, my lord, 2009 to 2015, my
But
lord.
tell me, Mr. Secretary, tell me one thing. There was an order to consider the seniority, the representation as per the earlier recommendation subcommittee. This was in 29/5/2020.
My lord.
Now, thereafter, this reservation list has come up
My lord.
on 29/7/2020.
22, my lord.
2022.
My lord, the
So
final seniority list, my lord.
That means was the representations reconsidered as per the earlier?
No, my lord. As per the subcommittee's report, no, my lord.
But this is of later point of time.
Yes.
After 2 years, this has been passed.
Yes.
So without considering reconsidering the subcommittee report.
Yes, my lord. So that's why, my lord, we have put to challenge this, my lord.
Mr.
And
Nabam,
while issuing the
Mr. Nabam, the challenge in two of the petitions of Mr. Saikia and one petition, Mr. Chaudhary, where the seniority list of 2022 is put to challenge. Was it published after taking into consideration the order dated 29/5/2020?
Kindly come to 133, madam.
133.
This is the memorandum, madam, issued by the government, madam.
Yes.
The detail has been given. Second paragraph can be started. And the petitioner name is
Claims have been examined. And
Ramarete, yes, madam, his name is okay. Ramarete, then Dominic, all the petitioners names are there. It was considered.
no, my lord, provisional seniority list, my lord.
Application also, madam.
On the basis of the provisional seniority list, my lord, which we have filed objections, my lord.
without considering those objections, my lord, the final seniority list has been published, my lord. Paragraph 2, my lord.
But what about this 35/2025? Have you taken out any other move to reconsider? 35/2025 is the subject matter of challenge in Mr. Panging's petition.
Yes, my lord. Thereafter, my lord, after final seniority list also, my lord, we have approached the authorities, my
Committee
lord.
constituted to examine the various representation, that is on 35/25.
Yes, my lord.
That is new representation, my lord.
all were settled. And you representative. Representative filed in 2025. When these writ petitions were. Also.
This, my lord, seniority list is also challenged, my lord, in this writ petition, my lord. And, my lord, by the order of this honorable court, my lord. Order dated, my lord.
This 29/7/2022 is the subject matter of challenge here.
Yes, my lord. And the DPC is also, my lord. And this honorable court, while issuing notice by order dated 24, my lord. And my lord, kindly, I'm sorry, my lord. Kindly see the, my lord, last line of the, my lord, last page of the, my lord, seniority list, my lord. This final seniority list is also subject to outcome of any decision to be taken by the government, my lord. May I read, my lord? Page 136, my lord. Bottom, my lord. The seniority position of Amy, my lord, may skip, my lord, as indicated in serial number 12, very subject to outcome of the Honorable High Court, eternal permanent bench in WS such and such. It is not connected to us, my lord. My lord may skip. And others. And as regards to serial number 41, 42, my lord. 42 is the petitioner, my lord. Number 1, and 42 is the petitioner number 42. 45, 40, and 47, the petitioners in, my lord, Mr. Chaudhary's, my lord, case, my lord. Will 44, 45, and 47.
Will remain?
Will remain same unless the concerned authority of the government consider their request for promotion with retrospective of the officiating promotion or any order comes from the Honorable High Court, my lord. That's why, my lord, we have again represented before the authority, and authority considered our grievances and constituted a committee, my lord, which was, my lord, put to challenge in the, my lord, writ petition in item number 5, my lord. And in this present writ petition, my lord, while issuing notice by an order dated, my lord, 24/11/2022, my lord, this honorable court in my writ petition, my lord, order dated 24/11/2022, my lord.
27?
24/11/2022, my lord.
Interim order.
Interim order, my lord.
Yes.
May I read, my lord?
Yes.
The effect of the impugned seniority list dated 29/7/2022 shall be subject to outcome of the writ petition. It is further provided that pendency of the writ petition shall not be a bar for the concerned authority to revisit the seniority position, my lord. Accordingly, my lord, the committee was constituted, my lord, to revisit the entire, my lord, seniority position, my lord, which was put to challenge in the writ petition, my lord, in item number 5, my lord. And there is a stay of and, my lord, in response to, my lord, my writ petition, my lord, the state has filed affidavit, my lord, saying that, my lord, at paragraph 9, my lord, paragraph 19, my lord, otherwise they have admitted my vacancy position, my lord, vacancy position of 2008, my lord. May I read, my lord? Paragraph 19, my lord, of the counter affidavit filed by the respondent number 2, my lord.
Affidavit file. In 4/59, there has been affidavit file. Yes, affidavit. Yes.
May I read, my lord?
Yes.
Page 8, paragraph 19. With regards to the statement made in paragraph 20, 21 and 22 of the writ petition,
Page
page 8, my lord,
8.
of the affidavit filed by the respondent number 2, my lord,
Page 8, paragraph.
19, my lord.
Yes.
May I read, my lord? That with regard to the statement made in paragraph 20, 21 and 22 of the writ petition, the answering respondent begs to state that the petitioners having been promoted as assistant engineer in Department of Hydropower Development on officiating basis by order dated 4/2/2009 and having been successfully considered to regulation promotion by order dated 31/10/2019, the services of the petitioner ought to have been regularized with effect from 4/2/2009 for the clear vacancy arose in 2008. The respondent respectfully submit that the petitioners were given regular prospective promotion with effect from the date of departmental promotion committee, which is as per recommendation of the departmental promotion committee dated 31/10/2009 only on the following rules as follows, my lord. Citing the rules, my lord, as my lord, as contained in the Swami's, my lord, compilation, my lord. Under Rule 612 of the Guidelines for Department Promotion Committee, Swami's compilation of the seniority and promotion, the Department Promotion Committee enjoys full discretion to devise their own method and procedures for objective assessment of the suitability of candidates who are to be considered by them in order to ensure greater selectivity in the matter of promotion and for having uniform procedures for assessment of the Department Promotion Committee. Ignoring, my lord, all the, my lord, the ratios laid down by the Supreme Court regarding the, my lord, continuous officiating promotion, my lord. Relying purely on the, my lord, a compilation of the Swami's handbook, my lord. Otherwise, they have admitted that, my lord, there is a vacancy in the year 2008, my lord. And I have already shown the committee's report, my lord, identifying the vacancy also, my lord. My lord, while subscribing, my lord, the legal submission of the senior counsel, my lord. In addition to that, my lord, I would like to, my lord, place only one judgment, my lord, regarding, my lord, continuous officiating promotion, my lord. 2025 for SSC. I have given the book, my lord. 2025 for SSC 127, my lord. Paragraph 40 onward, my lord.
Name?
Name, my lord, P. Ram Mohan Rao versus K. Srinivas and others, my lord. Right. 2025 for SSC 127. P. Ram Mohan Rao, K. Srinivasan. Relying on the, my lord, the direct recruitment case, my lord.
During lunch hour, asked to remove that one.
Here also, my lord, officiating promotions were given from 1990 to 1995, my lord, and were regularized, my lord, by 2025, my lord, 2005, my lord, which was put to challenge by the direct recruitees, my lord. The government has, my lord, recognized the officiating, my lord, appointments, my lord, as a continuous, my lord. The continuous officiating service were recognized for a regular, my lord, for counting, my lord, seniority, my lord. Paragraph 40, my lord.
48.
41st, 40, my lord.
40.
Yes, my lord. Thereafter, my lord. Married, my lord. Seen thus, the fundamental issue that boils down for consideration is whether period of officiating a service of the temporary appointed assistant executive engineers between 1990 to 1992, including the appellant hearing, should be taken into account for considering the seniority over and above the 1997 batch of the regularly appointed candidates through APPSC private respondent hearing. 41, my lord. The constitutional bench of this court in direct recruit case 2 in class 2 engineering officer association, after considering the whole earlier decision, summarized the legal position with regard to the determination of seniority in the service in para 47 of the judgment for the purpose of present controversy. Paras A and B of the 47 are relevant. My lord, this direct recruitment has been quoted, my lord. And my lord, now my lord, come to page paragraph 48, my lord. Further, it is admitted that the services of the appellants under similar situated candidates employed between 1990 and 1995 were regularized by such and such dated 27/6/2005, which was not challenged before any forum and has attained finality. It is strike that once the services of the employees are regularized, well, this is important, my lord, the ad hoc or stopgap nature of appointment does not survive. In this regard, we may gainfully refer to Santosh Kumar versus State of AP, wherein while dealing with the similar issues and same service rules, the court upheld the regulation of the service of the temporary employees with retrospective effect and granted them seniority from the date of initial appointment, holding their cases falls under proposition B of the direct recruitment case, my lord. And ultimately, my lord, paragraph, my lord, 58, my lord. Merit, my lord. In the wake of the discussions and made above, we answer the issue in the affirmative and holds that the period of officiating service, that is period between 1990 to 2005 of the appellant and the base of the assistant engineer appointed between 1990 and 92 have to be counted as a regular service for determining the seniority, entitling them to place above the 1997 base as regularly appointed candidates, private respondent herein seniority list. The state government has fully justified in issuing the revised OIM, which is unassailable in the eyes of the law, my lord. Here, the department has rectified the, my lord, the mistakes, my lord. And in the same judgment, my lord, regarding the, my lord, power of the review, my lord, paragraph 51 onwards, my lord. May I read, my lord?
Yes.
The division bench of the High Court gave imprimatur to the contention of the private respondents, the regularly appointed candidates of the base 97. The issuance of sessions rendered the government, state government, functus officio, thereby precluding it from both revisiting or reopening the matter and issuing revised GOM dated sessions. Consequently, the division bench allowed the writ petition filed by the private respondent herein and quashed the revised GOM, observing as follows. In para 19, after taking a final decision,
52 is important, 52.
Madam,
It cannot be disputed.
yes, it cannot be disputed that the rule-making power of the legislature cannot be curtailed or nullified by an application of the concept of functus officio. The principle of functus officio normally applies to a judicial forum or a quasi-judicial authority and could have no application to the rule-making authority, which is within the domain of the state government by virtue of Article 245 of the Constitution of India, my lord. Now, government has, my lord, taken a decision, my lord, to re-examine the entire matter, my lord. Not new representation based on my lord, all earlier, based on the earlier representation, my lord, the government has taken a decision to review the, my lord, entire matter, my lord, by an, my lord, order dated 35/2025, which was put to challenge by the, my lord, the clients of the Mr. Dicky Pagi, my lord. Yes, my lord. And I have filed a, my lord, vacation petition, my lord, in the same line, my lord, that in my writ petition, my lord, there is direction by this honorable court that, my lord, there shall be no bar to revisit the entire seniority position, my lord, of the petitioners, my lord, of the petitioners. And in
You have
this,
filed IA in the Panging's case.
yes, my lord, for vacation, my lord,
IA number
207,
20.
And in fact, my lord, in my
Now
writ petition,
2025.
yes, yes, my lord. And in fact, my lord, in the present writ petition, my lord, the writ petitioners in my lord, item number 5, they have implemented, my lord, in our writ petition, my lord. They are parties in the writ petition, and they knew the order passed in this writ petition, my lord, that there shall be no bar for re-examining the entire matter, my lord. Despite that, my lord, order was suppressed and obtained this order, my lord, in writ item number 5, my lord. Obliged, my lord.
Yes. Madam, you're for with Mr. Chaudhary.
I'm in item number 6 and 8. So far as item number 6 is concerned, WPC 14 of 2022, I am representing the private respondents number 11 to 14.
In WPC?
14 of 2022. Okay.
Yes, and item number?
And item number 8, WPC 295 of 2022.
Yes, you are
for respondent number 2 to 5.
Same respondent.
Same respondent. And in the third one, I'm not a party, but by my learned friend, Mr. Saikia, we are not parties.
Yes.
At the outset, I will just indicate the broad arguments that I'll be making. Number one is, so far as the proposition number 2B of directed case is concerned.
Mr. Mazumdar, there are two aspects. One, this court entering into the merits whole hog, and the other aspects are the observations made even at the stage of publishing the final, so-called final gradation list.
Yes, I'm coming to that, man. I have understood. Your Lordship is possibly indicating
the second aspect.
Yes,
and more so when there is an observation in 14 that
subcommittee report
that there will be no bar. Justice Tagia's order.
Yes.
So in that view of the matter, the application of Akadas may not be a proper approach. May not be.
Absolutely.
And Akadas was, that was obviously, was passed on a particular set of facts, where it appears that the one officer had overreached the order of the court and tried to pass orders when the court was in session of the matter.
Exactly.
On that aspect. Akadas, I think we can be distinguishable.
And possibly, yes, will not.
So, and the final gradation which Mr. Saikia has pointed out, the last line, that they also thought that it was not tentative, it was not final, it was tentative, and followed by the order of challenge in Mr. Panging's petition. Whether an exercise, whole hog exercise by the authorities would be a better option than then for the court to enter into this merits. Only on that you can.
In my humble submission, so far as that aspect of the matter is concerned, the subcommittee report possibly.
See, you can have arguments to counter Mr. Chaudhary or Mr. Saikia on the point of law. That in spite of direct recruit case and all those cases,
they are not entitled.
The approach of this in these cases where the challenge is being instituted by them, the approach of the government is a fair approach, a reasonable approach, trying to bring a finality to the thing. That argument of yours will still be open
My lord,
in case there is a final decision against you.
my lord.
We do not know about the final decision.
After the
More so after the order of 2025 was passed to reconsider everything.
My lord, to that matter, I'll immediately respond, my lord. Possibly some of the findings recorded by that subcommittee are not correct, and possibly that report has not taken into consideration certain judgments passed by the Supreme Court in this matter by these petitioners. I'll point out.
That is the exact reason
My lord,
why we are still posing the question to you.
my lord.
You have the opportunity to file representation, convince the committee or whoever will take a final decision. We can also qualify that while taking a decision, hearing to the aggrieved parties or concerned parties would also be given.
I want us to, my lord.
To that extent also.
My lord, my lord.
You may have a case that subcommittee initial report, if that is whole hog taken into account,
My lord.
some prejudice may be caused to you because everything does not appear to have been taken into account by the initial subcommittee. You may be correct in contending.
My lord.
You can convince this committee, whoever will be reconsidering
My lord.
this is a decision.
True, my lord.
And their case is also that the administration cannot be bogged down by that you cannot review. You can review.
My lord.
You can always take a correct position of law.
May I submit?
Yes.
In fact, if according to this subcommittee report, if the matter is again reopened, possibly it will go against the judgments passed by the Supreme Court. So that is possibly not possible. This is what I'll indicate. There are two judgments which have not been pointed out. In fact,
But
my lord,
it is but you are not challenging.
my lord,
Your clients are not challenging the new move of the government.
my lord, subcommittee report ultimately we would have challenged. We are
You are
not.
not challenging. You will not be allowed to make the submission.
My
Parliament
lord,
can make the submission against 35/20/25.
my lord, subcommittee report we did not challenge for the simple reason that it only said that you dispose of the representation.
Yes.
And representations have been disposed of.
No, after 35/20/25, it has not been disposed of.
No,
Those representation are disposed of, culminating in the gradation list.
yes.
This is a new move of the government of 35/20/25.
Well,
These are new representation.
I'll come to that, my lord. My lord, every time sir, they file a representation, government passes an order, the issues which are settled cannot be reopened. My lord,
That argument you are entitled to.
my lord, I'll point out, man, from the fact.
That argument we anticipated that argument.
My lord, I'm
It cannot be an unending exercise.
Yes,
Every
my
time
lord. Every time
you
because
you file a representation
and
directly,
more
you
so-
open up.
yes, my lord, that is what I'll be indicating. My lord, my first submission will be the proposition number B in directorate case will not be applicable in this case for the simple reason that in the direct recruit case, the reliance was placed on an earlier judgment of 1997, that is Patwardhan's case. There was no dispute that the vacancies existed, and that is why this proposition. Similarly, my lord, Agarnath, they also, your lordship has read, my lord, Agarnath. Agarnath, they also, it said that yes, if there is vacancy, then there is no dispute with this proposition that if initial appointment was ad hoc also, then that can be taken into consideration. But here, our whole issue is there is no vacancy, and that is the reason why they cannot be given retrospective promotion. There are two judgments where, my lord, the writ petitioners themselves filed a writ petition, and this issue has been settled. But this has not been pointed out to your lordship, my lord. I'll come to that. These are part of the record itself.
Brought by us.
And brought by us. They did not. And the interim order passed in this WPC 14, my lord, 295, was vacated once. After that, my lord, out of the 4 persons who I am representing, 2 were promoted during the pendency of this petition. Before the remaining 2 could be promoted, they filed another IA. Then, because of the paucity of time, my lord, court said that all I do, don't make the promotion today, we'll hear it. And that hearing could not take place. That is why we are here today. So this interim order passed in this case, by which we are prevented from getting the promotion, was vacated once. Considering all the materials on record and suppression of one particular DPC of 2012. I am coming to that, my lord. This is one aspect. And so far as that proposition number 2 is concerned, as I said, here the whole issue is whether there is vacancy existing or not. In this case, there are plethora of materials, my lord, which will show government materials that there is no vacancy which they are agitating. So in that view of the matter, this proposition number 2 will not apply to them. And Agornath Dey is very clear, which said, my lord, yes, we are clarifying it because as your lordship immediately indicated, proposition number A and B, it appears there is some inconsistency. Then my learned friend Mr. Chaudhary has pointed out that Agornath Dey has clarified. But Agornath Dey has very clearly said to cover the cases where initial appointment is made against an existing vacancy, my lord. And this is our case. If there is an existing vacancy, the matter would have been different. But in this case, there is no existing vacancy. In that view of the matter,
How do you say that there is no existing vacancy?
well, I'm coming to that, my lord. I'm coming to that. There is government stand is clear, documents are clear. And
Let's see.
yes, my lord. One more thing, my lord. The judgment, please.
Then, see, initially 2005, two dates.
My lord.
2005 and 7, they were allowed to officiate.
My lord, their initial.
They're allowed to officiate, but they were still given the pay of junior engineer.
Yes.
5 and 7. So let us, for the time being, not even take into consideration 5 and 7.
Yes.
2009, they were given pay scale of an assistant engineer.
My lord, what has happened?
So can you say that on 2009 there was no vacancy?
Yes, we can say there are two things. My lord.
Let us see documents.
My lord, before that, I'm just pointing out the judgment on which my learned friend has relied on. Also, in paragraph 2, very clearly says that there were vacancies.
No, that I've understood. There is a precondition
That there
of
has to be
existence
vacancy.
of a vacancy.
Yes.
To claim a seniority.
Yes.
Seniority over the others.
Yes.
Now you are contending that in
There's
these
no
cases
vacancy.
they were given the officiating arrangement without there being a vacancy.
Yes.
Now just
My lord, I'm coming to this. My lord, will kindly see first from the petition what is the nature of appointment. That will show, my lord.
no, that those are not conclusive. Mr. Nabam, yes, this part needs to be.
Well,
you are the government. You have to.
Well, I'm
say
pointing
that
out.
2009 there was no vacancy.
My lord, one
or was
thing-
there a vacancy?
My learned friend.
We'll come to you. Be prepared.
Just 1 minute. Man. Their initial appointment was against the direct recruit vacancy in which we were appointed before they could be regularized. So, and their appointment says, moment a regular appointment is made,
Let us see.
that is what I'm showing, man.
Where?
Yes. Lordship, may kindly turn to first page 31, my lord,
Of this
of WPC 14,
14.
my lord. Oh, sir, 31.
Page? Page?
My lord. Yes.
61.
My lord, may I kindly turn to first page. No, initial appointment.
No, initiative.
2005, at page 59, madam.
On transfer whole charts.
Sorry, focus. Page 59, madam.
59.
My lord.
Petition number 1.
Petition number 1.
Yes, please.
On transfer of Mr. So-and-so from hydropower subdivision, Itanagar, terminated his petition number 1, my lord, is allowed to hold the current charge of assistant engineer, so-and-so, on an interim arrangement till posting of a regular AE. This stopgap arrangement will not confer him any right for claiming financial and other specific benefit. Next page, Lord, will kindly see, 29th August 2007.
All petitioners.
In this case, in this manner appointment letter, all the 3 petitioners are appointed. 4 of them.
In fact, Mr. Shakias.
Mr. Sekia's client also, my lord,
Yeah.
Mr. Damarete.
Come to the 2009 thing, when they were given regular scale.
Yes, I'm coming to 2009 today. 2009. This is also there after this. I'm coming to that, man. Page 61, Lord, kindly see.
61 is 2007.
2007. What is the nature of appointment, Lord, kindly see. The first paragraph says it is functional. In partial modification of the earlier letter dated 12/8/2005, of the Governor of Arunachal Pradesh is pleased to order further continuation of the promotion of the following junior engineers to the post of assistant engineer civil on functional basis in their own scale of pay. And then third paragraph, Lordship, will kindly see, the functional promotion appointment is against the quota reserved for the direct recruitment of the assistant engineer civil, and as soon as the government appoints direct recruitees to the functional promotion will stand terminated.
You're reading page?
Page 61, my lord. Ah.
It's one. Yeah, until.
It's 5 o'clock.
This one is correct, possibly.
We cannot see this. Can't see this.
Well, continue.
Malad, item number 4, man, I was called, man. I'm no more there actually as a standing council, man.
Okay, did we pass any interim order? Madam, you are there?
Yes, there.
Who was on the other side?
He was online.
Online. Arbitration matter, my lord.
Okay, arbitration.
Appointment.
So who will take the instructions? It's for appointment of arbitrator pending since 2022.
Yes. Malad, actually, when I was there, we filed an objection. That's beyond the limitation period. So, it should be within 3 years, Malad.
Is there a clause?
Malad?
Is there a clause?
Arbitration clause is there, but it's regarding this.
No. For limitation point which you are raising.
Yes.
Is there any stipulation of limitation?
Yes, Malad, as per the Malad, various judgments of Supreme Court, within 3 years, it should be a cause of action.
Who will be appearing? We want to put it.
She will be appearing.
Madam, you will be appearing now?
Yes.
I'll be appearing now.
So we finish off this matter. Either we decide this way or that way. Cannot remain pending of matter of this nature. Council is there online for the petitioner. As per your convenience, when can we have? Thursday?
Lordship, next week.
No, this Thursday, day after tomorrow.
Lordship, day after tomorrow, I'm not here.
Then next Monday?
Yes, Monday.
Next Monday? Mr.
Yes, sir.
Prakash, you're Mr.
Yes,
Prakash?
Malad, no issues with investment.
Okay, okay. Heard, what is your name? What Prakash?
Abhinav Prakash.
Heard 3A Prakash, Learned Council for the petitioner who has appeared online. Also heard Ms. So Learned State Council.
Yes, Lordship.
State Council who has submitted that there has been a change of council and she would be appearing for the respondents.
Yes,
First of, she has prayed for some accommodation, Para, considering that this case for appointment of arbitrator is pending since the year 2022. List for consideration on Monday. Please give the date. On which date?
9/2.
On which date an endeavor would be made for disposal of the matter.
Obliged.
Malad.
Matt, Your Lordship.
Yes.
Hello, we were, I was reading page 64, my lord.
Yes.
So this is the letter, order of appointment on which they are banking. That is of 4th of February 2009. Page 64, my lord.
Yes, please.
I'm just reading the first paragraph. The Governor of Arunachal Pradesh is pleased to order officiating promotion of following JE as assistant engineer civil in the pay scale of rupees so. Their names are at serial number 5, 7, and then
Page 66.
page 66, the name of other person is also there. Now, first, they pay at page 64, after the names panel serial number 1, let's look kindly see. The officiating appointment is purely in exigency of work and that it would not count for the purpose of seniority or regular promotion or continuance in the post. So this will show that there was no vacancy against which they were actually appointed in the purely in the exigency of work. Not only that, my lord. Now, Lord, will kindly take up the affidavit filed by the government.
By the government.
Ah. We hear it in 295. 295 petition one है.
Yes.
But the government has filed the affidavit, which is more effective in the second writ petition, there's WPC 295. There, the government has
You
given
want
the-
me to take the
My lord,
petition,
my-
writ
my-
petition or the affidavit?
affidavit filed by the government in 295. Vacancy position,
Given the next format, the year-wise vacancy.
yes, ma'am.
Year, both malak for direct and then promotees.
The affidavit is in the IA.
Is no, madam, is in the main petition, madam.
Madam,
295 main petition, affidavit in opposition by
It would be dated 29 January 2025.
29 January 2025.
I think this is in the IA.
Copy of
Page number 184.
Yeah, to copy the लिखो दिया. Running page 185.
Page
185, madam. Running
185.
running page.
Yes.
84. 84.
To 184.
24.
Ah.
84.
Yeah. First one,
184.
first 184, man.
184.
My 184 and 185 both I'll be referring. 184 is the vacancy position and sanctioned post of AE under DHPD with effect from 2004 to 2013. Lord, should kindly note this period up to 2013. This was the vacancy position. From Lordship has got my 184. From here, I'm showing that 2004, there were 20 sanctioned posts. Left first column, my lord. 20 sanctioned, but number of vacancies 10. Post filled up 20. That is, this part is for promotion quota. So 20% have been, all posts have been filled up through promotion, although there were not vacancies. Right hand side, my lord, row, the column, Lord will find vacancy for direct recruitment quota. Number of vacancies 10 because total was 20. So 50% will be for direct recruit. 10 that comes to 10. None was filled up, so 10%. 10 posts remained unfilled. This way they have worked out serial number.
In 2005, access.
My lord, from 2005 onwards till 2012, Lord will find the first, second, third column post filled up always in excess. And then 2012, Lord will find 42 is the first column. Total to stand 42. Lord has got, my lord. Serial last but one, 2012, year 2012. Then next is 42. That is the total strength, sanction post. Then number of vacancies for the promotion is 21. And post filled up 20, all post filled up. And one left, because out of 21, 20 filled up, one left. Then right hand side, you will find that for direct recruitment, 21 total, and then post filled up 22, and then excess 1. This is the position. Now, Lordship finds from here that in 2012, there were 21 posts to be for filling up through promotion. Now, Lordship will kindly see the page 185. 185, they have given the list of officers appointed as AE from 84, 184.
185.
185. Next page.
184.
185. 185 I have just read.
Yeah.
185 I am showing. Here, the government has given the list of officers who were appointed from 97 onwards prior to the writ petitioners. And 97 to 2005, they have given up to 18 Lord will find up to 90 appointed up to 1997. Then comes 19 and 20. These two are very important. Imi Angu and Amopalo. Why I'm saying all these 20 persons were promoted in a DPC held in 24th of July 2012. I'll show the DPC, my lord. And in the DPC, all these 20 persons were recommended. That was put to challenge by 10 persons, and challenge was only in respect of the serial number 19 and 20, because they were given retrospective promotion from 2005 when they were initially appointed on officiating basis. But I am just clarifying again. These 20 persons who were officiating
Were recommended for promotion.
came within the zone of consideration, and they were recommended for promotion in the DPC held on 24th of July 2012. These two persons at serial number 19 and 20 were also given retrospective promotion from 2005, that is the date from which they were officiating.
And their date of officiating is prior to the commissioners.
And the date of officiating of these two persons are prior to the officiating date of the writ petitioners. Writ petitioners did not come within the zone of consideration. That is why they were not considered. And even the regularization of these two persons at serial number 19 and 20 were challenged on the ground that there were actually 18 vacancies. And these two were in excess. They could not have been given from 2005.
Because in 2005 also, there were 4 excess promotions.
My lord, then page 184 again, Lord will find in 2005 also, there were 4 in excess.
Yes.
Now, I'm just showing your lordship the DPC of 2012, which your lordship will find at page 133, running page 133, my lord.
Of the repetition.
This 295.
Affidavit.
My lord, affidavit filed by the Ask, my lord. We filed. Respond number 225.
On page?
Running page will be 133. That is prior to the government. We filed.
Yeah.
Now, my lord, lordship's court, my lord, page 133. The DPC meeting was held on 24/7/2012 under the chairmanship of the Chief Secretary to the Government of Arunachal Pradesh in his office chamber for regularization of esteemed engineer civil promoted on officiating basis during the year 97, 98, 2002, 2005 in pursuance of the judgment and order of the Honorable High Court dated so-and-so, Itanagar bench in WPC number 53 AP of 2008, constituted by DPC number so-and-so. Now, in this DPC, next page, Lord will find
These are the same persons.
all these persons which I have indicated from page 185, my lord.
Page?
These persons were those who are mentioned in the list of officers appointed on officiating basis at page 185. Same persons. All of them were senior to the present petitioners. Now, next page, page 134, Lord will find the names of these two persons, Imi Angu and Amapalo, at serial number 19 and 20.
Yes.
This recommendation of 24/7/2012 was put to challenge. And the this honorable court, this order is annexed here. Lordship will find at page, again the affidavit filed by the government, this order is annexed at page 193. It was by Honorable Justice K.R. Surana of 26/10/2021.
It was challenged in WPC 66.
My lord. Page 196, I just see 2-3 paragraphs, not much, my lord. Page 196, paragraph 2, Lord, should you kindly listen. This was challenged by 2006 direct. My lord, 2006 direct recruit batch challenged this.
Six. Why should they challenge? They were already above this exercise done in 12.
They challenged only those 2 persons who were given promotion retrospectively from 2005. According to them, they are not entitled. Because there was no vacancy for these 2 persons. For the remaining, my lord, there was no challenge. Challenge was only in respect of 2 of them.
On repetition size, 295. 294 and a half.
Achha.
Challenge was with regard to serial number 18 and 19.
18 and 19. My lord, this WPC 295, which is before Lordship, at page 78, Lordship will find the order. WPC 295 itself.
Which order?
This order of Honorable Justice Surana. WPC
196 also?
196 also same. I can read from anywhere, Your Lordship.
Paragraph 9.
So I'm reading from 196, my lord. Paragraph 2, Lordship will kindly see. By filing this writ petition under 226 of the Constitution of India, 10 petitioners herein claiming common cause of action have assailed the recommendations made by the DPC in its minutes held or dated 24/7/2012 to regularize the promotion made to the respondent number 6 and 7 from the post of Junior Engineer Civil to the post of Assistant Engineer from the date of officiating promotion, that is 21/5/2005 and 31/8/2005 respectively. The petitioners have also prayed for issuance of direction upon the respondent authorities to prepare a seniority list of AE in the ratio of 50-50, etc. Then, my lord, Lordship will kindly turn to page 201, para 9. Entire judgment I will not read, my lord. Next, good. Para 9, 10, and 12 are my relevant. And the concluding part, para 15.
11 to 9.
Para 9, when I'm reading page 201. By filing affidavit in opposition, the stand of the respondent number 2 is to the effect that statement made in paragraph 9 of the writ petition was admitted, wherein it was alleged that the authorities had promoted many JE to the vacant post, possibly direct recruited post of AE, and that the authorities had appointed 7 out of 16 posts of AE without considering the direct recruitment quota, but it is stated that same was not done in exigency of work and in the interest of public service. The further stand is to the effect that in the year 2005, 10 posts of AE was filled up by direct recruitment through APSC, and that in the year 2007, 10, 13, requisition was made to the APSC for making direct recruitment to 4, 8, and 5 AE, respectively, being 50% posts meant for direct recruitment quota, and accordingly, it is projected that at present, ratio of 50:50 for direct and promotion quota has been maintained. It is seen that in no uncertain words, it has been mentioned in the affidavit of opposition filed by the state in WPC 543 AP of 2005 that as on the date when the said affidavit of opposition was filed, the sanctioned strength of AE under DOHPD under the government of AP was 31, and that vacancy position year-wise in the said post for the year 94 was 12, for the year 97 it was 8, and for the year 2005 it was 11 posts. It was further stand of the state respondents that as per recruitment rule, 50% of 31 posts would be 16, because normally first vacancy goes to the promotee and 15 will go to the direct recruitment, and that due to exigency of work, 20 posts of AE, which were vacant during 97 had been filled up on officiating basis, but due to pending court case, the officiating promotion could not be released, and therefore, on withdrawal of the court cases and on recommendation of DPC on 23/7/2003, the officiating service of 9 persons named therein had been regularized. The further stand of the state respondents was to the effect that now 7 more posts are being regularized against promotion quota, and out of 15 posts against direct recruit quota, the regulation of 10 posts have already been sent to the APSC. The stand taken in paragraph 5, 7, and 8 of the affirmation has been reproduced in the judgment and order dated so-and-so, passed in WPC so-and-so. The DPC held on 24/7/2012 had recommended promotion regulation of officers whose names appear at serial number 1 to 4 and 6 to 20. The promotion to the private respondent 6 and 7 was with effect from 2005 and 2005, August and May, respectively, whereas the persons whose name appeared at serial number 1 to 4 and 6 to 7 were regularized with effect from 24/7/1997. Persons at serial number 8 was regularized with effect from 9/7/97. Person at 9 was regularized with effect from 15/5/2002. Person at 10 was regularized with effect from 98. Person at serial number 11 was regularized with effect from 98. Person at serial number 12 was regularized with effect from 98. Person at 13 and 14 were regularized from 99. Person at serial number 15 was regularized with effect from 2002. Person at serial number 16 was regularized with effect from 99. And person at 17 was regularized from 99. And 18 from 99. Now, no document has been produced by the state respondents regarding the nature of reference which was made to the DPC, and moreover, no document has been brought on record by the state respondents to show the cadre strength of AE in DOHPD as on 21/5/2005 and 31/8/2005. The date and from which the officiating promotion to respondent number 6 and 7 were regularized. Therefore, the only material available before this court is the affidavit in opposition filed by the state respondents in connection with WPC number so-and-so, which was filed on 11/11/2005, wherein it has been stated specifically that as on the date, said date's sanction strength of AE under DOHPD was 31, and that vacancy position in the year 2005 was only 11. As indicated above, the said fact is also reproduced in the judgment and order dated 17/1/2006, passed in WPC 543. Therefore, the inevitable conclusion of the court is to the effect that the recommendation made by the DPC held on 24/7/2012 had failed to consider the relevant recruitment rules in force while recommending regulation of officiating promotion given to respondent number 6 and 7 from 21/5/2005 and 31/8/2008, respectively. In view of the challenge made only to the regulation of officiating promotion given to respondent 6 and 7, the court is of the considered opinion that the promotion of respondent 6 and 7 were recommended by the DPC in excess of quota for promotion as per the recruitment rules of 91 as well as 2005. Resultantly, the like 13 we can skip. Now, Lordship may straight we go to page 204 page, para 15, my lord. In view of the discussions above, the writ petition succeeds, and accordingly the writ petition stands allowed. Resultantly, the recommendation of the DPC held on 24/7/2012 is set aside insofar as it concerns recommendations made for regularization of officiating promotion made to respondent number 6 and 7 from 21/5/2005 and 31/8/2005, respectively, without affecting any other recommendations made thereunder, and consequently, it would be open to the state respondents to prepare a fresh senatorial list of AE in Department of DOBHP. Now, they have challenged this order before the division bench.
Is it WPC 543?
But this WPC 543 has been referred here. That is also relevant. I'll read that. But before that, I'm just reading the judgment passed by the Honorable Division Bench in the writ appeal filed by them. Only the operative part is page 209, para 10. Because they preferred an appeal matter, writ appeal number 11 of 2021, which is available at page 205. Now I'll be reading para 8 at page 208, madam.
इसमें है
May I read para 8, my lord? We have noticed that the aforesaid aspect as to whether ad hoc promotion in the year 2005 was made following the due procedure of law had not been gone into in the judgment impugned. Secondly, even if there was a breakdown of the quota rule of 50:50 for giving the benefit of promotion, prima facie it would not be a case for setting aside such promotion. The law in this respect has been laid down by the Supreme Court to the extent that if any promotion was made without adhering to quota rule, the other group can be given the seniority benefit in view of such quota rule being not adhered to. Considering the prima facie case being made out, the balance of convenience as well as irreparable loss that the appellant may suffer in the interim, it is provided that judgment impugned dated so in WPC 66 shall remain stayed until further orders. However, implication of staying the judgment would not render any undue benefit to the appellant for the purpose of promotion to the next higher cadre in respect of the seniority aspect in the cadre in the near future by taking his date of promotion to be as per the BPC dated 24/7/2012. For such purpose, the department may work out interstate seniority between appellant, promotee, and the respondent direct recruits for making any further promotion by strictly following the provisions of law in the matter. Now, the writ appeal is pending.
2012 PCC was never challenged by them.
This was of 29/11/21.
My lord,
Writ appeal is pending.
pending, my lord.
Fix on second person.
These two minutes.
My lord, this 2012 DPC, 24 July 2012 DPC,
Not considering the petitioners.
where the petitioners were not considered, and two persons who were
2012.
and two persons who were senior to the petitioners and were given retrospective promotion is also under challenge. And the petitioners have not challenged this DPC of 24/7/2012.
Even they have not doing this repetition.
And this was not referred to in the writ petition, and this was the main ground on which this interim order was vacated, my lord. Now, my lord, there was a reference of one WPC 543. That is important because the writ petitioners filed that writ petition, my lord, earlier. I'm told, my lord, there is no reference in the writ petition, either of these writ petitions, about their judgment where the petitioners filed a writ petition in 2005.
What was the outcome?
Outcome is, my lord, their petition, their relief was not granted to them. My lord, Lordship will find at page 201. 14, I'm sorry, my lord, for this. Page 201 of WPC 14, my lord.
Oh, in the, not in the affidavit.
Not in this, my lord.
Just WPC 14.
My lord.
Oh, 14 we have.
Yes.
201.
My lord, page 201. Because the judgment of Honorable Justice Surana makes a reference of WPC 543, my lord. And this is this 543, filed by the writ petitioners. Present
201 is not part of the affidavit or what?
Yes, part of the affidavit.
Or not the petition.
No, my lord. Running page 201, my lord.
Oh, affidavit, you have another file.
295 or affidavit.
Affidavit is very complicated. We have got separate files for affidavits. 14. 201.
My lord.
201.
An advertisement of 2005 for direct recruitment was put to challenge by this writ petitioners, my lord, saying that there were prior vacancies, etc., which was turned on by the Honorable Court, my lord, and there is no appeal against this.
Let's come.
page 201, my lord. WPC 543 AP of 2005. नाम भी तो कैसा ही है। My lord, the names of present writ petitioners are at serial number 2, 4, and 7.
1, 2.
Oh, yes, 1 also. 1, 2, 4, 7.
Which one? Affidavit filed by?
Debit filed by us.
WPC 201, WPC 295.
In WPC 290.
WPC 14.
Huh? 14.
WPC 14.
14. I'm sorry, man. Page 201, I'm reading, my lord. In the second paragraph, my lord, at page 203, I think.
203.
In this writ petition,
Yes.
the petitioners have challenged a public advertisement number so-and-so dated 30th of August 2005, inviting applications for filling up of 10 posts of assistant engineer under the Hydropower Development Department. The present writ petition has been filed by the petitioners who are serving as junior engineer under the Hydropower Department. The basis of challenge of the advertisement is that in terms of the recruitment rules, namely Assistant Engineers Civil Group B Recruitment Rules 1991, published by so-and-so dated 10/1/1991, which was subsequently modified by notification number so-and-so 19/5/1999. As per service rules, 50% of the posts of assistant engineer available in the department should be filled up by way of promotion from among the working junior engineer in the department, and rest 50% should be filled up by direct recruitment. The grievance of the petitioner, my lord, will kindly say, is that by order number so-and-so dated 8/2/2005, 11 posts of assistant engineer were created for the department by the government, and out of which 50% should have been earmarked towards promotion quota. That is the grievance. 11 posts were created, 50% should have been for promotion and 50% should have been for direct recruitment. And since 10 posts were advertised, they have challenged this. And they have relied on saying that there were more posts. Now, paragraph 5, Lordship will kindly see, an affidavit in opposition was been filed on behalf of the state respondents. In order to appreciate the contention of the state respondents, paragraph 5, 7, and 8 of the affidavit of opposition are quoted.
Yes.
Now, paragraph 5, my lord, I have read. There are the paragraph 5, 7, and 8 of the affidavit of opposition are quoted here, which says, my lord, that with regard to the statement made in paragraph 3, the deponent humbly states that as per related existing recruitment rule, the post of assistant engineer are to be filled up 50% by promotion and 50% by direct recruitment. This sanctioned strength of assistant engineer civil under Hydropower Department and the government of AP as on date is 31. Year-wise vacancy of assistant engineer are as follows: 94, 12, 97, 8, 2005, 11. Total 31. As per recruitment rule, 50% of 31 posts will be 15 plus 1, that is 16, because normally first vacancy goes to the promotee, and 15 posts will go to the direct recruitment. In exigency of work, 20 posts of assistant engineer civil, which were vacant during 1997, has been filled up on officiating basis, but due to pending court case, the officiating ad hoc service could not be regularized. On withdrawal of the court cases and on recommendation of Departmental Promotion Committee held on 23/7/2003, the officiating or ad hoc services of the following persons have been regularized as detailed below. So names are given, my lord. Now 7 more posts are being regularized against promotion quota. Out of 15 posts against direct recruitment quota, regularization for 10 have already been sent to Public Service Commission, but due to pending court case at the time of sending requisition to Public Service Commission, 5 could not be proposed through Public Service Commission for consideration of a penal against direct quota. That with regard to the statement made in para 5, the deponent begs to state that requisition for 10 posts of assistant engineer civil has been sent to Public Service Commission and requisition of 5 more posts which could not be sent due to pending court cases at the time is being sent to Public Service Commission, as 50% of 31 posts is 15 posts. That with regard to the statement in para 6 and 7, deponent humbly states that as already stated in para 5, DPC is being held for consideration of promotion of 7 posts of assistant engineer against promotion quota. The names of petitioners who are under zone of consideration shall be placed before the DPC. Mr. So for the petitioner has submitted that although the affidavit in opposition, the post sanctioned by the authority for the year 94, 97 and 2005 taken note of posts created by order number so dated 13/9/1993 have not been taken note of. If that would have been taken note of, some more posts would have been available towards promotion quota. This was, my lord, rejected. Para 7, I'm not reading. 8, Lordship will kindly see. I have considered the rival submissions made by the learned counsel for the parties. It is seen that 31 posts of assistant engineer are available in the department, and out of which the quota for direct recruitment is 15 and remaining 16 for to be filled up by promotion. Some of the eligible departmental candidates have already been promoted within their quota and they are holding the charge of assistant engineer. The departmental candidates at any rate are not entitled to cross the barrier to hold the posts earmarked to be filled up by direct recruitment. Out of 15 available posts for direct recruitment, 10 posts have been advertised by impugn advertisement number so and the requisition for remaining 5 could not be sent to the commission due to pending court cases. The allegation for non-inclusion of the vacancies created by order dated 13/9/1993 has no basis. This was the basis, my lord. Inasmuch as the said posts were taken note of showing those in the year 1994, in view of the fact that those under 93/94 for period of up to 28/2/1994, which was issued by notification dated so. Thus, it is clear that all the posts of assistant engineer created for the department has taken note of in calculating the total number of posts of assistant engineer as disclosed in the counter affidavit of the state. In that view of the matter, the apprehension of the petitioner is misplaced and accordingly this petition is rejected. Well, they are claiming that there are vacancies, but the government record says no, there is no vacancy. That's what I'm trying to project, my lord. And subsequently, when they filed a writ petition and subcommittee was formed, subcommittee gave some finding. Subcommittee at the end of the their report says that kindly dispose of their representation. Their representation was disposed of, which is under challenge in the second petition. But after the writ petition was first writ petition was filed, 295. In 295, there in the first petition there was no stay. 14, WBC 14. 295, when the gradation list was prepared and challenged, there was an interim stay for which could not be promoted further. Then we filed an application for vacating the interim order. There, and my lord, so far as our date of appointment, the lordship has already taken, my lord. Our date of appointment is 24/9/2009, 24/8/2009. And their regulation is 31/10/2019. 31/10/2009.
That is what they are challenging. Why have you given us 31/10/19?
Yes, ma'am.
It should relate back
to 2000.
The date of the official
February 2009.
Yes.
Yes. Well, I am trying to show that there is no vacancy in which they can be accommodated, number one. And number two, even in 2012, when all the existing vacancies were taken into consideration and all those 20 vacant posts were filled up by way of DPC recommendation, that DPC recommendation taken into consideration the last 2 persons which are above them. That was also put to challenge, and that is writ appeal is pending. So far as they are concerned, they are below those 2 persons.
Writ appeal is pending. This one.
In respect of remaining 2 persons.
11 of 22 is 21 is pending.
Yes. Writ appeal is pending, man.
11 of 21.
I know.
Next date is 2/3.
It is regarding, I am one of the council, my lord, here.
Okay,
It is
welcome.
regarding the, my lord, vacancy position of the 2005, my lord. Here in my case, my lord, it's a position is 2009.
We thought after hearing all the parties, matter will be simpler. It's going to be more complicated.
In fact, these things ought to have been pointed out in my humble submission. My lord. Now I am pointing out the documents and the averment of the state affidavit where it is clear that there was no vacancy, my lord, in 2009 for them. And they are also aware 2012 recommendation, if they do not challenge, my lord, 2012 DPC recommendation has taken into consideration all existing vacancies, number one. And number two, all those persons who come within the zone of consideration, they do not come. If they do not come, they cannot get, my lord, retrospective promotion prior to 2012.
He have also pointed out that in the 2008, 2009 appointment,
Yes, my lord.
there are certain clauses
My lord.
which bars them to make any claim further.
Exactly, my lord. Exactly.
But we are only concerned with those tentative observations by the government
My lord.
that we are open to further consideration. Why is this? Why another subcommittee has been constituted?
My lord, your lordship
Which
knows,
is the
people,
subject
my
matter-
lord, people keep on submitting representation, my lord, to get rid of this problem.
Which is the
They-
subject matter of Mr. Panging's petition.
My lord, Mr. Panging will point out certain paragraphs from his affidavit that will show the background in which this vacancy position was given.
No, that is okay. We are not,
My lord.
merits we are considering, but even otherwise,
My lord.
in the final gradation list, the last observation.
My lord.
Then in the representation, another observation that we are going to reconsider everything.
My lord,
by representation.
your lordship is rightly indicating there are certain things where the final seal has to be given. Otherwise, every time a representation comes, a new order comes, my lord, in one case, my lord, I had to point out to court number 5 in the principal seat that in that those compassionate upon matters, once everything is over, again a representation comes, and then if nothing happens in the department, they file a representation, and there's, I should not say, my lord, some court pass an order. All right, you consider and pass an order. Moment they rejects this representation, there's another petition.
No, that cannot equate with this. Here, the government has taken a conscious stand.
My lord, government has taken a stand, but ultimately
Not
government.
that you want they want a direction for consideration. They have on their own, they have said, okay, we will consider.
Well, there is a reason why. My lord, what happens, my lord, they keep on filing representation, and the subcommittee report in the in between, my lord, they have mentioned certain thing which is not consistent with the record.
No,
that is why
representation, it
My
can be disposed of. We have already done it. There is no scope of any rejection.
Yes, my lord, yes.
They have not done.
They have disposed of, my lord.
No, in the last one, by which is the subject matter of Mr. Panging's petition, 31-7.
My lord, that is why before your lordship, but every time a representative comes and something is given. My lord, in the second lead petition.
Mr. Nabam will be an affix from this side as well as this side.
But he has got some beautiful ways no one knows through which he will proceed.
To maneuver.
Maneuver, he knows. That expertise he has developed, my lord, over time. My lord,
How to wriggle out.
Yeah, how to wriggle out. My lord. Correct phrase. is how to
Successfully wriggle out.
Successfully wriggling out. My lord, in WPC, this 295, when interim order was there, for which we could not be promoted, then we filed an IA for vacating the interim order. There are certain observations were made by this honorable court that possibly will have some relevance, my lord.
But the status quo as of today, that day is still being maintained.
No, the subsequent one. My lord, we are.
No, after the observation, did something happen?
Yes. Yes, my lord. After those observations, out of 4 persons, 2 were promoted. And then another IU was filed for the remaining 2 when the government started exercise, because earlier there were 2 vacancies only. When 2 more vacancies came up for consideration of the case of the other 2 persons, then they came up with another IA again to stay. Now, due to paucity of time, the court said that please don't proceed. You proceed with the DPC proceedings, but don't pass any final order. Because of that, my lord, the remaining 2 persons could not be, my lord, promoted till now. And there, my lord, this Honorable Court has made a observation that in their writ petition, they have not disclosed about the 2012 DPC, because unless they challenge the 2012 DPC, how can they say that there were vacancies? Because 2012 DPC has taken into consideration all the existing vacancies till 2012. And only 2 persons' recommendations were under challenge, and those 2 persons were also appointed prior to the writ petitioners.
Okay.
This is they filed an IA 218. From there, I'll show you the order was annexed. IA 218 का file है. सब जगह नहीं देखा. सब entered to बोल से.
I-218 is for?
Or passing a fresh interim order, my lord, after the earlier interim order was vacated, my lord.
In WBC 284? No.
WBC 295, my lord. 295, second writ petition. No.
Which order?
My lordship, can you turn to page 27 first, man? That was the first order passed in WBC 295 on 31/7/2024. 31/7/2024.
Yes.
And the next page, my lord, page 28, the last but one paragraph says that in view of the above submission, this court finds it fit to direct the state respondents may not conduct DPC with respect to the promotion for the post of so-and-so to the post of executive engineer based on the impugned seniority list dated 29/7/2022. Now, this order was vacated at our instance, my lord, by an order dated 18/9/2024 at page 31, my lord.
Interpreted. It is an interpreted order.
After hearing both the parties.
After hearing both the parties.
Both the parties were heard, my lord, and there is no challenge to this order. And para 9 at page 35, I am trying to show my. Page 35, para 9. Therefore, in the light of the observations made in the order passed in WPC 66 APF 2013 and taking a note of the DPC minutes dated 24/7/2012, which is annexed to this interlocutory application, the inevitable impression of the court is that the connected writ petition WPC 295 of APF 2024, the opposite party number 1 to 3 have suppressed the said DPC minors dated 24/7/2012. Then the last para 11, my lord. It is needless to mention that as the said DPC minors has neither been annexed by the opposite party number 1 to 3 either in so or in so and so. Then the next paragraph, my lord, the applicants herein are all direct recruitees to the post of assistant engineer. From the judgment passed in WPC 66 AP of 2013, it appeared that out of 20 recommendations made by the DPC, 2 recommendations were held to be in excess. All the remaining 18 junior engineers, therefore, got promoted to the post of assistant engineer. There is nothing on record to show that the petitioner had challenged the DPC minutes dated 24/7/2012 or any other orders of the promotions which was issued by the competent authority for the 18 other recommended officers. In view of this, my lord, this page at page 38, para 19, this on the court has just one sentence only, my lord. Para 19 at page 38, my lord.
Yes.
Last sentence, therefore, this is a case where the stay is likely to cause hardship to the applicants. And therefore, it was vacated, my lord. Next page, page 39, para 21. Pursuant to this order, vacating the interim order, the government has passed an order of promotion of 16 persons, but only 16 vacancies were there. So from out of 4 persons, my lord, only 2 could be accommodated. That your lordship will find at page 40, my lord. Next page.
Out of 4 direct recruits of 2009.
There are 16 persons, my lord. Pursuant to this order, the government made the promotion, recommendation, and out of 4
direct recruits of
2009, only 2 could be accommodated at serial number 15 and 16. Remaining 2 could not be done because there were no other vacancies. And for the remaining vacancies, when the
But
second...
this was in 24.
Yes, man, after this order. After this order, my lord. Because this order stayed the entire, my lord, promotion exercise, which affected them also. They are not a party in the writ petition.
What about the serial numbers 1 to 14? Who are they?
They are above, they are
seniors.
Seniors, my lord.
They are from promotion.
They are from promotion quota, my lord. 1 to 14.
15, 16?
15, 16, we 2, my lord. Out of 4, 2 persons. Respondents.
In 2009, there were 4 recruits.
You are direct recruitee.
Ha, my lord. So this is further promotion.
For the next promotion to
Next
executive
promotion
engineer.
to executive engineer, which was stayed initially by the interim order. This is a promotion to the next post of executive engineer, my lord, which was stayed by the interim order.
So 295 was on the aspect of further promotion.
295 was challenging the seniority list in the rank of assistant engineer.
Understood.
So when that is under challenge, the court
was
will
stayed.
make further promotion to the executive engineer.
It was stayed. So
It was stayed.
court vacated.
Then court vacated, then we were given permission.
2 of you.
Yes, 2 of us, because there were no other vacancies for the remaining 2. For the remaining,
Otherwise, you are 4.
otherwise we are 4.
To get to response number. Response number 11 to 14 in WPC 14. And direct recruit number 2009. Rest are the subsequent direct recruits. Mane earnings.
Yes.
In the WPC 295, response number
2 to 5.
2 to 5 are the persons whom I am representing, and the remaining are
They are direct recruits of 2009 and remaining are subsequent direct. 2012.
yes, remaining are of 2012.
Direct.
And my lord, the question of application of this quota rule, 50% promotion, if they are of the same year, my lord, the petitioners are yet to be adjudged to be a regular appointee or a promotee of 2009. That is the issue before your lordship. My lord, in a case where there is no dispute about the appointment directly and promotion in the same year, then the question of quota, application of quota rule will come. Here, the question of application of quota rule will not arise because they are fighting first to get entry in 2009 because they are of 2019. They were given regularization from 2009. They are praying for being directed to be considered from 2009. Only when that is allowed, then the question of will come. If they are of the same year, then the application of quota rule will come. So the application of quota rule, directed recruitment promotee, and the Supreme Court judgments, etc., will not have any application in this case for the simple reason that they are not admittedly the regular promotee of 2009. They are regular promotee of 2019. That is my submission.
No, that is one of the points Mr. Chaudhary was urging.
Yes. Well, that's what I'm saying. I'm responding to my learned friend's reply, submission. My learned friend submitted that as per, since the rules do not provide for the determination of seniority amongst direct recruitment promotees, the general procedure should be followed laid down by the Honorable Supreme Court. My submission is that is applicable in a case where admittedly both the groups are of the same year. Here we are of 2009, they are of 2019. They are before your lordship for a determination that they should get a retrospective promotion from 2009. Once that is decided in their favor, only then the question of application of quota rule will come. Not now. Now, because application of quota rule presupposes entry of both the groups in the same year. They were admittedly entrants of 2019. They are saying that there are vacancies. So kindly direct the department to give us a retrospective promotion from 2009. If that prayer is granted, then the question of application of this rule will come. That is my submission, madam. Because unless your lordship holds that they are of 2009, the application of quota rule will not come. So they are in the first step. In a case where admittedly both are of the same year, then the question of application of this rule will come. That is my submission, madam, before your lordship.
Visiting basis.
No, that was not the submission. That his submission was that the entry into the service of his clients should be held to be from 2009, and by maintaining the rota, quota versus rota, that 50%.
Yes.
If they are in excess, they can be moved down. If you are in excess, you can be moved down. But exercise is to be made by holding them to be senior to you in entry as an assistant engineer in the cadre.
Yes, my lord, that's what I'm saying.
So your thing is that they have not substantially been appointed as AE in the year 2009. That has happened in 2019.
And
so it's
now
not in the same year, much thereafter.
Yes, my lord, my submission is possibly I'm not very much clear. What I'm saying is, my lord, so far as they are concerned, they are praying before your lordship that kindly consider us to be given retrospective promotion from 2009. Only when they succeed in this thing. And for the purpose of succeeding in the first point, my lord, they will have to show that there are vacancies. There are ample documents to show, my lord. I have shown the judgments also.
Yes,
so this shows that vacancy was not there. And unless they change, my lord, the DPC of 2012, they cannot go prior to 2012. And 2012 had taken into consideration all the existing vacancies existing up to 2012, 24th of July. That is my submission.
Okay.
And my lord, this direct recruit judgment, I should not show that Patwardhan judgment, well, just two minutes, lordship. Court note take two. Well, lordship will kindly.
Citation, please.
My lord, this is that 1997, sorry, 1977, 3 SCC, page 399, SB Patwardhan versus State of Maharashtra. I don't para 39, but this was relied on by the
Direct recruitment.
on Supreme Court in the direct recruit case to hold that even if the initial appointment is not in accordance with rules, if they continue, is proposition B, my lord. For the purpose of proposition B, the Honorable Supreme Court has relied on this judgment in direct recruit case.
Which
Para
paragraph?
para 39, the concluding part, my lord. Para 39, the last sentence, my lord. Starting from the words, it is on the record. Lordship has got, my lord. Just above para 40, my lord.
39. It is on record.
It is on the record of these writ petitions that officiating deputy engineers were not confirmed, even though substantive vacancies were available in which they could have been confirmed. It is in this background and relying on the judgment of Patwardhan, my lord, in the direct recruit case, Supreme Court has held the proposition B, my lord. Because I read, because as your lordship has right in the beginning indicated that there is inconsistency between proposition A and proposition B.
No, the A and B, there is one concept of confirmation.
Yes.
So,
So far as
confirmation is only a formality.
Yes, my lord.
But that is what the Supreme Court wanted to clarify.
Yes. There is no dispute with that, my lord. But so far as continuation is concerned, in proposition 1, the Honorable Supreme Court says that if the initial appointment is not made in accordance with rules, then this officiating period till the regulation will not be counted. But in the second proposition B, again Supreme Court says it will be counted. Now that is because if
you want to contend that to have appointment to be deemed even as substantive appointment,
yes,
the precondition of having a vacancy, clear vacancy is there,
yes,
required.
Yes. And
if vacancy is not there,
then
whatever means you are being inducted into service, it cannot be held to be a substantive appointment. Therefore, you cannot reckon your seniority from
exactly. That is my submission.
That's it.
That's my submission.
Yes, who will know? You are for?
I am for, my lord, in item number 6.
Petitioner.
WPC 14. No, my lord. Respondent number 3 to 10. Writ petitioner in, my lord, WPC 284/2025.
You are a petitioner in one case.
One case. This is item number 5.
Petitioner in
284/2025.
284 of 25 and respondent numbers?
Respondent numbers 3 to 10 in WPC 14. Check out.
14 of 22.
Yes, my lord, 22. Then, my lord, in 459. Check out.
You are there in 459?
Yes, I'm in every case, my lord.
Respondent numbers?
Respondent number, just a moment, my lord. Usko bhi dekho. 3 to 10.
459 of 25?
Yes, 459.
25. Is it 25 or 24?
22, my lord.
459 is also 22?
Yes, my lord. That's why there is a long pending case.
Respondent numbers?
3 to 10.
3 to 10?
Yes.
Same 3 to 10 in 14
Yes, yes, yes. And in this, my lord, WPC 295
of
2024, 6 to 13. We are 18 numbers, my lord, direct recruit of 2012 batch.
Yes.
Yes. Now, if your lordship may kindly have my affidavit in WPC 14, respondent numbers 3 to 10. I will just point out the vacancy position when direct recruits were met.
Page
number 77, my lord. My lord, the Department of Hydropower Development was bifurcated from the Power Department. That was in 2004.
77. What is the submission? Department of?
Department of Hydropower Development was bifurcated from the Power Department. 2004.
Yes.
2004, my lord, there were 20 vacancies, career strength.
Career strength.
Yes.
In which one?
In
Hydropower.
DHPD, my lord. Hydropower Development.
New department, after the
Yes,
bifurcation.
after the bifurcation.
Or career strength in the post of AE.
AE, my lord, assistant engineer. Now, with the bifurcation of the new department, there were officers in the Ulster Power Department who were substantive post was junior engineer, was holding the officer-acting post of assistant engineer in the Power Department. 20 of them were brought in to the Power Department, and all these 20 posts were filled up by officers who were holding the post of assistant engineer on officer-acting basis. All of them. 10 should have been by direct recruitment, my lord. So that was not done. That from page 77, your lordship will get. All 20 were filled up by promotions. Although on officer-acting basis at that point of time.
Yes.
2005, my lord, another 11 posts were created, taking it to 31.
Yes, in the table.
Yes. And my lord will also recall the judgments also at that point of time, there were 31 posts that is admitted. So 2005, there were no recruitment. 2006, my lord, 10 direct recruitments were made. Total was 31, 10 was direct recruitment was made. First time. So, my lord, at that point of time, we get actually 15 and they get 16. They were already 20. 4 excess in 2006. Now, in 2007, another 6 posts were created. The post came to 37.
No, post 2007 it was 31 only.
Yes, 2007, 31. 2009, 37. By that time, only, my lord, 10 direct recruits, my lord, can take note of that. 2009, 37. Against that, another 4 direct recruits. 14. These 4 are the petitioners that the learned senior counsel, Mr. Majumdar, represents. So 2009 also excess promotion, my lord. Now, ultimately, we are 2012 batch. 8 appointments, direct recruitments. 2012, your lordship will kindly see 42 total post. So that 20 from 2004 remained, but in direct recruitment, my lord, there were 22. So 1 excess appointment. Only 1 excess appointment. 21 it should have been. So even if, my lord, so if anybody has a claim, it is the P2 in, my lord, WPC 459, who is now retired. Only he could have a claim that there was a vacancy, then I could have been considered because I was the senior most. That person is now retired. That is a factual position. So, my lord, in the absence of any vacancies, this 50-50 quota has to be adhered to, my lord. In the absence of any vacancies in the promotional quota, except for 1 in 2012, all the judgments relied upon, your lordship will recall by the learned senior counsel, that is subject to there being vacancies.
Yes.
So all these judgments, in my humble submission, my lord, will not apply, will not help the petitioners in this case, because there were no vacancies. Quota rule will have to be adhered to, my lord.
Yes.
So if your lordship sees, I will just point out what has happened there. After page 78, I will see the names. These are the persons who were promoted. They continued to hold these dates, my lord, date of appointment regulation. This is from their officiating promotion in the power department, my lord. They came in the 2004 in the DHPD. This is from the power department. So these are the persons up to 20 who held the post of assistant engineer officiating basis in 2004 after the 20 posts were created, taking all the 20 posts away. In the right side, your lordship will see direct recruitment. As I just pointed out, first 10 is 2006. Promotion already 20. Then 2009, 14. They have already 20. Here also 6 access. We are from 2012. I am representing serial number 15 to my lord. Serial number 15 to 22. Up to 21, my lord, there could not have been any issues.
Page 78 is slightly confusing.
My lord.
There are two broad columns. One is for promotion.
Yes.
One is for direct recruitment.
My lord.
From 97 to 2005.
Yes.
It has been shown that 20 persons were
Yes.
promoted.
Yes. This 97 is, my lord, I will show from the next document. This 97 is the date from which they were appointed on officiating basis in the power department before even they were brought into DHPD. It is that date in the power department, officiating appointment. I will show, my lord, if your lordship takes note of the names, your lordship, I will show the order. So they were already there. They were not regularly promoted on officiating basis, initially in the power department and thereafter in the DHPD also.
What about on the right column, right, direct recruitment?
Yes.
Is it?
First is matter 1 to 10.
Yes.
That is 2006. They were already 20, my lord, by that time. So 10 excess promotions.
Okay.
Then 4 more in 2009, direct recruits. That is the petitioners that my lord senior Mr. Malinda represents. 2009, 14, with the addition of 4. So, my lord, there are also 6 excess promotion. I represent from 2012, your lordship will see the year. From serial number 15, in the next page, your lordship will have the right-hand side column.
Next page.
Yes, 79. Up to 22, Rajan Mudang. This Rajan Mudang may be said to be an excess appointment. Because it should have been 21, because the cadre strength was 42. So who would have gotten which at serial number 21 on the left-hand side? Gula Ravi, who has now retired. That is the factual position, man. So as of 2012, the other lead petitioners, your lordship will at this WPC 14, their name finds place from 24, 25, and 27. So there is no question of these lead petitioners getting retrospective promotion from the date of their officiating promotion because there were no vacancies.
The long and short is that vacancy was not there.
Not there.
So even if one vacancy was there,
Yes.
there was a person who was senior to the petitioner. That
Yes.
is it.
Yes. That is my stand. So the contention that because of DPC not being held, despite we having the requisite length of qualification, that in my humble submission is misconceived. They may have had the requisite length of service, but there were no vacancies.
Yes.
At page 70, your lordship sees the name of the persons on the promotion side, my lord.
Page?
78.
Yes.
SL Chaudhary, Irshad Nabi and all this, right up to number 20, that is Amapalo. Your lordship will find that they were promoted by this order at page 80. That is why I was pointing out date of regularization which effect from their official promotion, most of them in their parent department. Only 18 and 19 in the DSPD department.
This part you're okay.
Yes. So these are same persons. 19, then the 20th one, your lordship will find at page 82. This is the 20th one, 2013. So the 20 post has already been filled up as of 2012. So now, as far as my lord Rota Kota is concerned, my lord, Senior was already addressed, I will just not repeat myself. But for my lord has seen the recruitment rules. There is nothing in the recruitment rule that says that the determination of seniority has to be by way of Rota Kota. So in the absence of anything in the rules, it is the length of service that will have to be considered, my lord. Apparently, we are senior. They had no vacancy. Their appointment is from 2019. Their claim now is that they should be given from their officiating promotion, on which that we have categorically shown that there were no vacancies. So since that prayer, my lord, in my humble submission, cannot be allowed, seniority, my lord, has been rightly granted to us.
Okay.
May I place some judgments, my lord?
Regarding what?
Regarding Rota Kota.
No, not required. Those are clear.
Yes. That is not in the rules. And N.K. Chauhan also, my lord. In fact, N.K. Chauhan, this has been, in fact, my lord, our division bench has been distinguished. It does not, N.K. Chauhan does not say that the Rota will follow Kota. It is not that. It will have to be there in the rules, my lord.
Okay, Mr. Navam.
But I am clear on the vacancy position, my lord. My lord, just a moment. Since I am the writ petitioner in the other writ petition, I filed the writ petition because, my lord will see, the impugn order is dated to 2025, my lord. 3 writ petitions filed. First was WPC 14, seeking, my lord, retrospective promotion from the date of the officiating opposition. Government files affidavit in that case, saying there were no vacancies.
Yes.
Then thereafter, my lord, WPC 459/2022 file. Same stand taken by the government. It is this document, my lord, I have taken from the government's affidavit. Says there are no vacancies.
Which one? 14, they have said no vacancy?
Yes, 459 also.
459.
Yes.
459, and I have just shown the government affidavit, my lord. There is a vacancy, my lord, in my respect, since 2008, my lord.
That, my learned senior will explain, my lord, there is the English is not very good. What they meant to say is totally different. I've shown from the records.
You're blaming it in the English language.
I am actually. It appears some words have missed, but what they have said is, in the claim that from 2008, they have been given from 2019. That is what they say. I've seen it. Now in 295, there is a categorical assertion. The same document was annexed, that there were no vacancies. Now they will have to show something, there were vacancies. Now, the government, after taking a categorical stand in all these petitions that there were no vacancies, what prompts them to, my lord, issue this order, my lord, when your lordship is in session of that matter from 2022, my lord? All these affidavits were filed in 2022-23. At this stage, my lord, why, my lord? That is the mala fide, my lord.
No, government has not said something in their favor. In Justice,
yes, I have
Justice
understood.
Tagia in the first order has said you can consider.
Yes, but I understand, my lord, but
Reconsideration doesn't mean that a favorable order for the petitioner is going to be passed.
of course, that is something I cannot say at this stage, but we all know what it means. Because after filing,
You are contending that in view of such categorical stand,
yes,
this somersault could not have been
Yes.
taken by the government.
yes,
That is
more so when your lordships are in session of this matter.
that,
the same is-
that perhaps will not come in. We cannot bring akadas.
Akadas maybe not, Akadas maybe not, but
Akadas.
your lordships are in session of the issues regarding
No,
retrospective promotion.
if the government takes a call, we may not be required to hold something on merits.
That is there, but that is my submission, my lord.
Of course, the call with the decision of the government,
Yes.
obviously it will be subject to judicial review.
It is there, my
That's a
lord.
different matter.
It would lead to just another ordinary litigation. This has been pending from 2022. Your lordship has already heard everybody, my lord, the whole day, my lord. If your lordship is convinced with our argument that there was no vacancies, everything follows, my lord. So where is the question of carrying out any exercise to determine all this? Rota quota cannot be applied. Sir. In any case, even if you assume that in the government affidavit, in Dharmaratha's case, that there is a statement that there was one vacancy, let them show any document because by which they substantiated, my lord. All these judgments, my lord, the Lord Senior Council relied upon. That categorically says
Yes.
that's my submission, my lord. All the judgments relied upon that says that there has to be vacancy. So since there is no vacancy, my lord, those judgments.
Okay. Okay. Final call by Mr. Nawam.
My lord.
Yeah. My lord, this matter since 11, my lord, your lordship will be
Your
hearing.
stand is contradictory.
My lord,
In
only
one
that,
case, you
my
have
lord.
to support them, in one other case, you have to support the other side.
my lord, only in one affidavit, my lord, in paragraph 8, where there is some slight indication is shown that 2008, some vacancy were there. How many vacancy not spell out, my lord?
No, we come to the merits. What about your decision to have the entire matter reconsidered? In spite of the clear stand which Mr. Master Panging is harping,
My lord.
in 3 of the affidavits you said that there is no vacancies.
Yes, my lord.
So the scope of reconsideration becomes nil,
Well-
negligible. But still you have kept another window open, or rather you have opened another window and inviting for.
For Mr. Intu Segia, my lord. Anyway, if
You
you
have
lord,
not opened the door, you have opened the window, he might have
My lord,
climbed in.
my lord, being a welfare government, my lord, we have to sometimes open, my lord,
Welfare
window. or door.
government.
You lordship has seen, my lord, the first committee report, my lord, there is no such any positive finding. What it only says to dispose of the representation submitted by the petitioners. Then subsequently, my lord, another subcommittee, my lord. My lord, why we go ahead with this committees, my lord, so that it will be convenient for the competent authority, my lord, to come to a
The
conclusion, my
constitution
lord.
of committee is not, that is not.
Your lordship is aware, it's not
We are-
mandatory also,
We
my
are not
lord. Yeah.
objecting to that. You
My
can
lord,
have it, committee is always better to have something specially heard, considered by a body.
My lord. But other side, they are harping, even the latest senior council was harping was second committee, my lord. Because second committee, subcommittee indicates something which favors them, my lord. So that's why they were harping on second subcommittee, my lord. And your lordship is rightly said, my lord. My lord, is committee report is not binding upon the government or competent authority, my lord. Now, that was the reason, my lord, why we have go ahead with this second subcommittee, my lord. Now, my lord, as others have said, my lord, now how this hydropower come into existence, my lord? This is very clear, my lord, 2004, my lord, after bifurcation from the power department. And how many, my lord, from the power department to man this new department we brought in, my lord. That is also clear, my lord. The sanction post was 20, we brought 20%, we regularized them. Totally nil, my lord, ought to have kept 10% for promotion, my lord, for direct recruitment. So now when you see, my lord, the first DPC, my lord, your lordship is very aware, my lord. Now, my lord, to have a DPC, there must be a clear-cut vacancy, my lord. Then, my lord, rest follows, my lord. ACR, DOCR, everything, my lord. Now, first DPC was held in 2012, my lord. That is not disputed, my lord.
Yes.
Then when you see, my lord, the 2012, my lord, DPC and the affidavit filed by the government, my lord, in 295, we have made a table, my lord. So what was the Qadar strength, my lord, is 42, my lord. Correct, my lord? So 42 in 2002, yes.
21, okay.
21. So 21, now the petitioners, my lord, whether the present petitioners, they falls under the 21 or not, they doesn't, my lord.
Oh.
They doesn't fall under the 21, my lord. Although there is one post is extra, even then there are senior most, my lord, Amapalo and another one. Yes, my lord. And the issue, my lord,
Yes.
the issue of that, my lord, that retrospective promotion, my lord, is still pending before the division bench, my lord. The retrospective promotion, my lord, of this 2%, my lord. Serial number 18 and 19, my lord.
DB is considering only promotions of retrospective promotion of 2%.
Yes, my lord. And that was challenged by, my lord, 2009 or 2006, my direct recruiters, my lord, saying, my lord, they have exceeded the promotion quota, my lord. And that contents was accepted by the landed single bench, and their promotion was, my lord, it was struck down, my lord. And against them, but again the challenge. Although admittedly there is an interim order, your lordship knows interim order is not the final order. So that final order is yet to be executed by the division bench, my lord, which my friend said, my lord, somewhere in March, no?
6 March.
6 March, yes, my lord. Now, my lord, if the division bench holds, yes, there is exceed of, my lord, promotion quota, then enter, I think this all this exercise will be, my lord, perhaps futile exercise, my lord. Right from 2004 to 2012, you have not challenged the DPC of 2012. Why? Time and again you are reminding me. Because 2012 DPC, my lord, that if I say, my lord, that, my lord, finalized the seniority claim or retrieve claim of the petitioners, my lord.
Assuming, Mr. Nabam, the challenge in the Honorable Division Bench,
my lord,
is decided in favor of the appellants.
Yes,
who are the promotees? What effect will it have? There are 2 persons.
my lord. Even then, my lord, if your lordship sees my 2012, the Qadar is 10, 42, the petitioner will not get, my lord.
Those 2 persons are not the petitioners here. They are
No, my lord. No, my lord. Now we have to see,
Those
my
2 persons are above the petitioners
yes, no doubt about that, my lord.
from the date of entry into the service.
Yes, yes, my lord. No doubt about that.
If the writ petition is allowed, my lord, they will go above the 2006 direct. Senior.
Because they were given, my lord, retrospective promotion 2005, my lord. And first recruitment of this direct recruitment was done 2006, my lord. The 10 post, my lord. They challenged, my lord. And if the appellant succeeds, my lord, obviously, my lord, they will be above the 2006 recruitment, my lord. Obviously, my lord. Now, the others, my lord, what they are saying, my lord, if your lordship sees, my lord, from the initial appointment, my lord, officiating, on pay scale, these are the, my lord, terms and conditions of the, my lord, appointment, my lord, that they will not claim regularization, seniority, all these things, my lord. No doubt, my lord, 2009, we have given, my lord, pay scale. Pay scale, my humble submission, does not constitute, my lord, there is a vacancy, my lord. Or you board into that cadre, my lord, permanently, my lord. Why we have given, my lord, if lordship those, my lord, ACP schemes, my lord. If someone is not given, my lord, regular promotion, the financial help, my lord. So that is the reason, my lord, why 2009, my lord, they are given the A pay scale, my lord. Now, what they are trying to project, my lord, look, you have given us pay scale of regular A in 2009, meaning there was a vacancy, my lord. That is the fallacy on the part of the petitioner to think of that, my lord.
No, Mr. Nawam, since on record you have shown that there is no vacancy,
My lord.
their assumption will not make a vacancy exist.
Correct, my lord.
What you are saying, but still then the point which needs to be decided may be slightly different. Whether the requirement of having a vacancy to consider the aspect of seniority vis-a-vis two quotas, one is a direct recruitment, one is from promotion.
My lord.
We're only on that. So far as vacancy not there, that's a factual position you have clarified.
My lord. My lord.
They cannot improve upon that. If
My
the
lord.
vacancy is not there, it's not there.
But my so far seniority is concerned, my lord. First, one has to, my lord, confirm in that cadre, my lord. The one has to born permanently in that cadre. Then only my lord, seniority will count. Suppose, my lord, we have promoted Mr. X from today, my lord. And sanction post is, my lord, 2007, my lord, 27. Then can he say, my lord, look, you have given me 2006, my senior should be counted from there, whereas there is no sanction post, my lord. I think in my understanding that cannot be, my lord. That exactly the petition they're asking for, my lord. But prior to regularization, they should be given seniority, my lord. From the death, my lord, they had given the pay scale at least 2009, my lord. That exactly they are asking for, which is not permissible, my lord, so far my understanding is concerned, my lord. Because promotion, regular cadre, and seniority is goes vis-a-vis, my lord. First one is to born in that cadre permanently. Then you get the seniority, my lord. Not prior to that, my lord.
Do you get yourself your submission back supported by any case law?
My lord,
to
today actually,
be born in a cadre to claim seniority. This is a proposition of law.
well, actually today when London Senior Counsel Mr. Ken Chaudhary raised up, I thought I'll raise an objection because it's for admission. I thought matter will be admitted and it will be posted for hearing, my lord. Anyway, my lord, I'll give that citation.
You should have raised the objection.
No, my lord, all the way.
Very
Mr. Chaudhary has come all the way, Mr. Majumdar, my lord, all the way from Guwahati. So I thought, my lord, I'll not raise any objection, my lord. I'll place that, my lord.
Our
citation, my
notes
lord.
have gone to 10 pages.
I'll give the citation, my lord.
Please
My
give
lord.
that.
Yeah. So basically, these are my submission, my lord.
Okay.
Obliged, my lord.
Short reply, a very short reply.
My lord, I'm afraid it cannot be very short because there is something which has been terribly twisted. Twisted out of.
Rejoinder cannot be long. What,
Lordship.
have any new facts been?
Yes, new facts, Lordship.
Where?
Lordship, I have filed an additional affidavit in WPC 14 showing the vacancy positions, Lordship.
Page?
It seems, Lordship, page 116. Before that, Lordship, the document on which.
Will you be in a position to dispute matter which is on record?
Yes, Lordship.
Oh.
Because this is not something on record, this is something manufactured out of thin air. I'm saying this, Lordship, because.
116.
Yes, Lordship, before that, Lordship, the document which they have been showing about all the parties which they have been showing, your Lordship will notice that there is no signature and factually it is wrong. I'll be showing from the documents that their documents.
That data.
Yes, that data is wrong, Lordship. Because, Lordship, we'll see in the document shown by them, they have shown that in 2005 there were 31. In 2005 there was a creation of 11 posts. In 2006 there was no post creation. 2007 there was no post creation. 2008 there was no post creation. This is factually wrong, Lordship. I should not say this, but I'm wondering who made this. Who created this document because even the signature is not there. And page 116 will refute that, Lordship.
We have the records.
My lord, this is signature is missing because it's a tabular form.
No,
It's not, my
Lordship.
Year-wise basis, we have given the figure.
No, even the year, even in 2008, there were 5 posts.
Yes,
This is a document which you have presented before this court.
My
For
lord.
presentation, you can get a type copy, no
My
problem
lord,
with that.
yes.
But it has to match with the original, or whoever is prepared. Is it there with the records?
My lord, if you lordship,
has
my
to
lord,
be
yes,
there.
my lord. We'll produce the record, no
It
problem.
has to be there.
Yes, my lord, because this has been based on the record.
Yes.
It cannot be based on the records because I have the,
Harping on the RTR, my report, that's correct.
yes, this RTI is based on their records, Lordship.
Page,
Page 116. This is an RTI inquiry, which was in which the information sought was the number of posts and the creation of posts along with the government order and date. Lordship will see in the column, in the first column is the post created in 2005. In the last, second last column, Lordship will see the number of posts which was created. The creation, the order number is also given. Then, if your Lordship will count, in 2005, there were 11 posts. 11 posts were created in 2005. Then in 2008, Lordship,
where do you get 11 posts?
Lordship will see in the second cornermost number of posts. It is given in numerical, Lordship.
Yes. Journal office 2.
Yes. 2, 2, 2, 6. Then 1, 2, 3, 4, 5, 11.
Repeat the 2011 creation. Correct. We are not disputing.
This I'm not disputing, Lordship. 11 posts.
Yes.
Then in the second, number 3 row, first column is the order date 2008, 9/6/2008. Then there, the second row, also 2008, 3/11/2008. Then on the third row, this is 2009, sorry. We'll just count 2008. In the corner, Lordship, we'll see 1, 2, 3, 4, and 5. In 2008, 5 posts were created. In 2009, Lordship will see the next one.
Yes.
The number 8/1/2009, then 2/3/2009, then 13/8/2009. All these, Lordship, 1, 2, 3, 4, 5, and 6. 6 posts were created.
That one is an ex-cadre.
Lordship?
Serial number 5 is an ex-cadre post.
Yes, ex-cadre post. But in their document, also they have mentioned that in 2006 or 2009, there were 6 posts. As per this, it is 6 posts. So they've missed out 2008, Lordship. 2008, 5 posts.
So what is your submission?
So my submission is, Lordship, the vacancy position which they have compiled, Lordship, this is not based on any records. The records are in fact contrary to this. Also, I have filed RTI seeking whether that post that which they were relying on in 2011, Wanimi Angu, whether that post to which he was promoted was in promotion quota or direct recruitment quota. In reply to that, also they have said it was in promotion quota. They are only harping on the 2012 DPC, but in the 2012 DPC, this was still for consideration of the officiating promotion on officiating basis in the years 1997, 1998, 2002, and 2005, Lordship. If we let go of, because we are not given pay scale till 2009, we were not going to get any benefit or any loss out of it, because anyways we were given pay scale benefit only in 2009, although we were eligible at that time. But if they say that there were no post creation at that time, that there was no post at that time, it would be wrong, Lordship, because so far as Yimi Angu is concerned, they have made a reply to the RTI saying that it was on promotion quota. Also, most importantly, Lordship, the whole fiasco is being created because, Lordship, what happened is that Department of Hydropower Development, initially when it was created, that time there were no regular employees.
Yes.
Yes. So everyone came.
Yes, sir.
Yes, everyone came.
Department.
Everyone entered the department through deputation and absorption. Now, in one RTI reply, out of the 20 posts, 13 posts, because in the recruitment rules there is nothing. Out of 20 posts, 13 posts of engineers who were absorbed at that time. In reply to an RTI, which I have also annexed in this additional affidavit, they have said that that appointment was made against direct recruitment quota. So they have counted that out. Those engineers were absorbed directly in the department before we were eligible for appointment. That was in 1997. So, Lordship, thereafter those vacancies came, Lordship. Now,
The bifurcation was done when?
1997.
97.
96, or I am not very sure, but it should be 96 or 97. So, Lordship, that RTI reply, Lordship may see at page 176 of the same additional affidavit. The RTI query was in page 177. Details of information required. Serial number 4. This, Lordship, page 177.
That's the one. On 176.
177.
Yes.
Additional affidavit.
Yes.
Lordship may see the serial number 4. Details of information required.
Yes.
Whether the following AEs were brought from PWD and later and absorbed as AE in DHPD were made against direct recruitment quota or promotion quota. These was the names. These are the persons whom the persons shown by my learned senior colleague, whom against whose post they were replaced, in the sense that they were promoted. Now, against this, the question was whether these persons were absorbed in direct recruitment quota or promotion quota. The answer to this, Lordship, will see page 176.
176.
Answer to this. This was our query. The answer to this is at page 176, the previous page. Question number 1. As per the records, appointment of all officers taken from PWD in the Department of Hydropower Development, as indicated in question number 1, were made against direct recruitment quota, a copy of seniority list on the basis of appointment promotion under DHPD. Then question number 2, officiating promotion of Yimi Angu was made against Sri Mrinal Bhattacharjee, who was promoted to the post of executive engineer, which the vacancy post of AE falls under in promotion quota. Now, Lordship, the whole, every confusion has been created by the government. They are saying one thing, doing another thing. In the, all these things, when the subcommittee submitted its report, it had seen all the records, and it is how they came to the conclusion that some people have been deprived. This is how these things are. Now they come to the court with an unsigned document showing a vacancy position, sends any document backing this up. And now they are saying that they will consider all the cases, not just our case. They'll reconsider everything. And they are coming to the court and saying that there are no vacancy positions. Either it is there or it is not there. They have to find it out. Can we, Lordship, government, I think, should decide which side it is on, because it seems it is blowing hot and cold at the same time. Your Lordship has seen the subcommittee report. In fact, after the subcommittee report, a provisional seniority list was made. Thereafter, an addendum was given that government will not take action upon the seniority, provisional seniority report, and will consider after seeing the report, after looking into the report of the subcommittee. Thereafter, without anything, again the final seniority list was published. Thereafter, we made a representation, and also Your Lordship will see the document which is impugned in my senior counsel, senior colleague, Mr. Panging's case. In that, Your Lordship will see at page 226, that is to consider not just the fresh representations, but the findings of the subcommittee as well. That is their Lordship. So if the government is going to do that, let them do it. If they come to the court with half-baked documents, I don't think this is a case in which this honorable court should decide this, whether or not how many vacancies were there, were this, were that. I am thinking it is, sorry to say, unreliable.
Okay, my lord, it's more clarification, my lord, so far. RTA reply and able wise that we have filed the affidavit, my lord. If your lordship says, my lord, there is no any difference, my lord. If your lordship says the total Qatar is reached 48, we also said 48, my lord. And 11, my lord, we have created, that is comes to 31. RTA reply also says 31. Only my sister was harping on 2008, we have not said anything. But when you—
No, they have shown 0 post in 2008.
When you said accumulate entire thing, my lord—
what I'm saying is, if the person knew, if it is based on records, then this kind of report would not come.
Now, total, my lord, they are not disputing, my lord. The total sanction posts are 6. We also say 6, my lord. If your lordship see, the total Qadar is 48. Here also 48, my lord. If your lordship see, my lord, the RTA reply.
Page
116, my lord.
The first one.
Yes, my lord.
Yes.
This is no date, nothing, I don't know.
Date is there, 20th of November.
20th November.
2012.
The extreme, my lord, if your lordship remark column, my lord, 6. 31 post, has your lordship got it, my lord? Extreme right, my lord. Remark, column number 6.
You may also contend that this also does not have any signature.
Exactly, I was supposed to say that, my lord. Before fingering out someone, my lord, one should be very careful, my lord.
No signature.
No, the RTA reply, there is no seal signature, nothing is there.
Forwarding letter.
Doesn't matter. Forward.
Even on the next page, no signature.
My lord. So, my lord, basically, my lord, total Qadar estimate is not disputed, my lord. The sanction, but all these things are. Oh, sorry. That's all, my lord.
My lord, I was just clarifying one thing, my lord. The senior counsel Mozumdar is also harping on the, my lord. The DPC held on 24/7/2012, saying that, my lord, since 2005 to 2012, all the vacancies were considered, my lord. And in that consideration, my lord, the writ petitioner in my case and the writ petitioner in her case, they were not considered, my lord. They are saying that, my lord. But in fact, my lord, DPC held in the year 2012 was for consideration of regularization of the promotions, officiating promotions, who were given in the year 1997, 1998, 2002, and 2005, my lord. Not beyond that, my lord. They have not considered the, my lord, vacancies of the 2006, 7, 9, 10, my lord. Only to, my lord, regularize the, my lord, officiating promotions from 1997 to 2005, my lord. Lordship, kindly have a
But
look for.
DPC can be held, a precondition is for, there has to be identification of vacancies.
Yes, my lord.
So
Here, my lord.
only up to 2005 that vacancies could be identified.
Yes, my lord. That's why, my
Are
lord.
not considered because there are no vacancies.
No, no, my lord. No, it is only for the regulation, my lord.
No, regulation can be done on a vacant post.
Yes, my lord. For vacant post of 2000 up to 2005, my lord.
Those are the vacancies available.
Yes,
because
my lord.
Vacancy cannot be unending. It has to be limited.
Yes, my lord. So there were subsequent vacancies, my lord.
Okay.
All right, my lord.
Okay, we'll consider. Oh, you're there? Okay. Heard. You have to write the names of, please give a list of, madam, who you are
Who is appearing
assisting,
for-
Mr. Chaudhary, Mr. Saikia. All of you give the name.
I will furnish.
Huh? For so and so appearing for so and so and so. Hearing is concluded, judgment is reserved.
Oh, yeah. Obliged.
Item number 9 and 10.
Just a minute. Yes, the first. First one. 9 and 10. What are these matters?
That is a tender matter, my lord. My learned friend is in a hurry to have the matter disposed.
Because there is
Today
stay,
is not possible.
That's why.
I is there. You have filed IA.
yes, IA is also there. IA is for
Say
scrapping,
vacating.
scrapping, no,
No.
my lord, scrapping of the subsequent tender, my lord. In
That is
where
a-
there is a stay, my lord.
That is under challenge. To be honest.
IA for?
Scrapping of the tender, my lord.
NIT,
Because,
my lord, that I have challenged, my lord. That is the subject matter of the.
because that validity of that
If
NIT
it
has
is my
expired.
decision goes.
No, you are challenging that.
Yes.
They want to withdraw it. Matter is there.
No, no, if they scrap the.
No, the main thing will remain, my lord. What happened, my lord, on the first NIT, he was L1. Because the rate was very high, we have cancelled it and we have issued another tender.
Now
subsequent-
your second one, you want to,
Because the validity has expired, my lord, during the pendency of this
first
case. my
your
lord.
challenge will be there.
That,
Second
that
one
first
is,
challenge will always be there, my lord.
Second-
That, at least this may be disposed of, my lord.
Second one.
The first challenge will always be there, my lord.
You-
Not.
Okay. Heard.
I was expecting the matter may be hard. I was, maybe the matter would be hard.
We'll have the matter for hearing on the date. Heard. Mr. Singh, you have filed this.
Yes, my lord. IA 307 of 2020.
You write this is
Second one,
307, 2005.
Second, my lord.
Heard Sri BK Singh, learned counsel for the applicants. Also heard Sri D. Pangi, learned counsel for the opposite party.
Petitioner.
How many of you are there? Or opposite
One,
party
one.
number one, writ petitioner. Any CGC, madam, who was there?
No.
CGC.
Actually,
Kato
they are
was
not.
there,
fact-
Kato? Anyone who
In the morning,
can record somebody's name?
Yes.
Anyone, any assistant of Marduk, Kato or anyone? Who normally appears?
Originally, Mr. Kato was there, my lord.
Any colleague of his, chamber associate? Okay. Fair.
My lord, the prayer is at page 14, my lord.
The instant I has been filed with the following rare. Full stop. The facts in brief, which may be required to be put on record, are that that an initial, that a tender notice, that an NIT dated
8125.
8/1/2025 was issued in which the opposite party number one petitioner had participated and was adjudged as the L1 bidder.
L1, my lord.
Full stop. However, for certain reasons, the said NIT was sought to be abandoned, cancelled, which is the subject matter of challenge in the
including
writ
the
petition.
subsequent NIT.
Full stop. In the meantime, the subsequent NIT, both are the subject matter of cancelled followed by another NIT. Full stop. The same action is the subject matter of challenge in the accompanying writ petition. Full stop. By the instant application, comma, as indicated above, the applicant FCI wants to scrap the second NIT for which leave has been sought for from this court. Full stop. Para. 3. Hanging the learned counsel for the opposite party number one writ petitioner has submitted that though on principle he may not have any objection to the aforesaid action which is intended to be taken, comma, he submits that there should not be, the same should be, that if the same is allowed to be done, a condition should be imposed that the rights of the petitioner which have been raised in the writ petition should not be adversely affected. Full stop. Para. After hearing the learned counsel, comma, this court is of the opinion that allowing the present prayer in this IA shall not cause any prejudice to the challenge instituted by the opposite party number one writ petitioner insofar as the action of cancelling the first NIT is concerned. Full stop. Para. Accordingly, leave to cancel the second NIT dated
25/3/2025.
25/3/2025 is granted, which however will not cause any prejudice to the right of the opposite party writ petitioner to maintain his challenge.
My lord, the main writ petition may be taken up next week, my lord, Wednesday.
I have no issues, madam.
Wednesday.
The writ petition may be listed for admission hearing on
11.
Wednesday next.
11/2.
Please give the date.
11/2/25, 26.
But there was an interim order, my lord.
Interim order for what?
No, now that interim order is not, the interim order was not to finalize this subsequent tender. It is now redundant.
Okay.
I hope they don't float another NIT in the meantime. That will be a difficult.
No, the first one is remaining there, man.
That is
Because
there,
it's
but if
challenging.
it's not in NIT, then
In view of the aforesaid development, comma, the interim order stands modified that in the meantime, there should not be any further steps, any steps taken by the FCI to go for a fresh NIT.
obliged, I do.
It has made a bar, my lord.
Yes, of
Don't
course.
go where
This will lead to another litigation, my
on
lord.
Wednesday.
Obliged.
My lord, the effort may be made to dispose of the
That's
matter. my
for
lord.
admission hearing.
Obliged.
On which
that-
date an endeavor will be made for disposal of the writ petition.
Obliged, my lord.
Item number 12.
Who's in 12? Dilip Saikya, Taku, Tumbu, Tanarini, Tinima, Mr. Tarak, G. Tarak, PWD, RWD. Anyone from his chamber? None appears for the parties on call. Tara, in the interest of justice. Matter is adjourned to be listed after 2 weeks.
Item number 13.
1-3. Madam Dungan.
Lordship, in this case, the respondents have, particularly the land department, have assessed our properties, misassessed our properties.
Services, pleadings are over.
Yeah, no, NHIDL has filed affidavit. The government has not filed affidavit.
What
But today,
is required?
Lordship,
Government affidavit is required.
Yes, government affidavit because they are the persons who have.
Mr. Nabam,
My lord.
will you file affidavit?
My lord, we'll file the affidavit if there is something wrong in the assessment or other things, my lord. Or if they are not satisfied with the rate which have.
Under certain act.
Yes.
If 64 is there, you can make a reference.
No, Lordship, they have not followed section 26. They have not made any exercise under section 26.
This can be a ground of in 64.
And then also,
Take instruction, you put it on record that what steps have you taken?
also Lordship, they have not made any, they have just given a rate, a flat rate for everything. No exercise has been done at all.
File your affidavit. And you are for whom?
5 and 6.
NHIDCL. You filed your affidavit.
But Lordship,
Let them file the affidavit then. Heard, Mr.
we, today was listed for hearing on the interim, Lordship.
Interim, what kind of interim?
Lordship, once they construct the road, then there is no point in assessment. Everything will be over. We are seeking only reassessment, Lordship. We're not questioning that this much you have to give, that much you have to give. That is not what we are saying.
What,
We are saying,
what do you have? What kind of property? Do you have Ziraat also?
Lordship?
Do you have got Ziraat, some construction, some rich?
Yes, construction, boundary walls, then some petitioners have this car wash.
Can you file affidavit soon? When
File.
can you file?
This is from.
We are only concerned, Lordship. Once that is done, then there cannot be a reassessment. We are seeking reassessment, Lordship. We are not saying you give me this.
The matter had come up on a number of occasions. Today suddenly will not grant an interim order.
Lordship, that is because the service was not complete and we had to complete the service in respect of respondents 5 and 6.
Please do not take up any activities which might make the petition futile. In fact, okay? You file the affidavit. It is a good office. We are not passing any order, but okay. Heard Ms. N. Dungan, learned counsel
Lordship, a fixed date may be given.
for the petitioners. Also heard Sri R.H. Nabam, the learned AAG, and you are Yadav.
Yes.
And what Yadav?
RBN.
R.V. Yadav, learned counsel for the NHIDCL. Put some Sri Yadav, learned counsel has, while Sri Yadav, the learned counsel, has submitted that affidavit in opposition has been filed by his client, the state is yet to file the affidavit. The counsel for the petitioner has contended that the stand of the state would be necessary for a complete adjudication of the matter. Considering the above, and as requested by the learned AEG, time of 2 weeks.
My lord,
this
is coming for the third time, my lord, 2025. This was filed on 27/10, my lord, 2025. So, my lord, at least 3 weeks, my lord. Time and again, I don't want to seek my lord time, my lord.
Okay.
But my lord, I'm only concerned that if something happens.
The time is granted, 3 weeks time is granted to enable the state respondents to file the affidavit. As urgency has been expressed, list this matter on today's what?
Today's third.
1, 2, 3, 3 weeks. We'll have it on 25th.
Oblige.
25th.
March.
Not March.
February.
February.
Item number 14.
14, contempt case.
Yes, Your Lordship. Your Lordship, in this matter, the respondent number 3 and 4 have been promoted and new incumbent have been taken the charge. So allow us to implead them, new incumbents.
3
and 5.
But you, madam, you need to issue a notice before you implead. If there is a change in the incumbents,
yes, Your Lordship,
you need to notify them that there is an order of this court which you need to comply. Then only you can file an impleadment.
Yes, Your Lordship.
This is a contempt petition. Unless you give an opportunity to a new incumbent
yes,
to comply or make him aware of this order, you cannot implead. Okay?
Yes.
Take care of this aspect. Otherwise, you will not allow your petition.
Yes.
Unnecessarily, don't spend time. Immediately issue a notice on your own as a as a counsel or from the petitioner himself?
Yes.
A representation along with a copy of the order. You know
Yes.
what to do. Okay, madam, your name?
S. Thomo.
S. Somo.
Yes, Your Lordship.
Miss S. Somo, I heard Miss S. Somo learned counsel for the petitioner. Also heard, yes, your names
Adrema,
for
respondent number 3.
Trian, yes,
And Honorable. Respondent number 4 and 5.
4 and 5, huh? Have you taken the names? Para. Ms. Somo, the learned counsel has submitted that there are change in certain incumbents holding the post in question, post S, PSTS in question, and therefore implement application is required to be filed. Para. In view of the aforesaid submission, matter is adjourned by 4 weeks to enable the learned counsel to take necessary steps. Full stop. It is needless to mention that before such implement application is filed, the new incumbents are required to be notified with the order, with the order of this court, which is the subject matter of this contempt petition, requesting for compliance. And proof of such communication is to be enclosed with the implement application.
Item number 16.
16.
Yes.
Yes.
My lord, I have received their reply affidavit in opposition today only. So next that may be fixed for admission on hearing.
Would you like to file any reply affidavit?
No,
You're not required.
not required. And my lord, other respondent, the private respondent number 4, so far they have not filed their reply.
But their service is not complete.
In that case, my lord, liberty may be given to file, to take a fresh step.
First steps, okay. Who is respondent number 4?
Is the private respondent.
Which place? What is the matter?
My
A
lord, the
dispute.
land dispute.
Okay. While the official respondents are represented by Ms. Pangu,
Yes, sir, Lord.
Madam, by Ms. Pangu, the London State Council, which has filed, and an affidavit has also been filed by respondent number 3, office notes indicate that respondent number 4 is yet to be served. Para, your name?
T. Sunil.
T. Sunil, learned counsel for the petitioner, is accordingly directed to take fresh steps for service of notice upon the respondent number 4, full stop. Such steps be taken by speed post with AD within 2 days from today. Full stop. List after 4 weeks, along with fresh service report. In the meantime, the petitioner would be at liberty to file rejoinder affidavit if so advised.
My lord, there is a interim.
Interim order passed earlier to continue till the next date of listing. What kind of interim is there? Mr. Sunil? What is the interim order?
My lord, the impugned order passed by the respondent number 4. That was state.
Okay, interim order stand. We will fix a date after 4 weeks, since there is an interim. List on 6th of March. 6th March.
My lord, I have some difficulties.
On 6th, then on 2nd March.
2nd March.
Okay.
Item number 17.
Yes, 17.
Lordship, instruction was I have already received and I have showed it to the honorable court also. It's in the last order, Lordship.
Okay.
But then notice has been issued again, Lordship. We have not filed affidavit.
You like to file affidavit?
We have been asked to, Lordship.
File affidavit then.
Yes, Lordship.
What was there in the last occasion? What had happened?
Lordship, otherwise, Lordship, as per my instruction, Lordship, they have already issued LOE letter of intent, Lordship.
Heard Ms. Su.
If
So
your
notice.
Lord,
Direct to file the response. Yeah, it was directed. Okay. Your name?
M. Doji,
Learned
on behalf of El Murtam.
counsel appearing on behalf of
El Murtam.
and learned counsel for the petition appear. Ms. Ete, the learned state counsel submits that instructions have been received based upon which the affidavit in opposition would be filed. Put the, see, according, filed for which she prays for some time. Matter accordingly stands adjourned by 4 weeks to enable the state to file affidavit in opposition. List on 27th of February.
Lordship, after 4 weeks, just note that may be given.
Okay, 9th of March.
Yes.
9 March.
All right.
Item number 18.
18 same, Lordship, this is similar matter. 17
Similar.
and 18.
You are appearing?
Yes,
Okay.
sir.
Same.
All right.
Item number 19 and 20.
Yeah, Lordship.
Yes.
I'm for the petitioner in item number 19, Lordship.
Hmm.
This matter pertains to the cancellation of ST certificate granted in against the respondent number 6 in writ petition number for item number 19.
You want the cancellation to be done?
Yes.
The ST certificate in favor of the respondent was 6.
Yes.
Did you, is the,
Since
are the guidelines in Madhuri Patil
yeah,
followed?
that was followed, and thereafter the scrutiny committee had passed an order. Passed the
May, Madam, before he process further, Madam, there's
Upholding the certificate.
no against
cancelling this.
cancellation.
Then,
That order was forwarded to DC Tawang, but no action has been taken so far.
okay.
That is why we have filed a representation, but no action has been taken. That is why this writ.
Why DC, Madam, sorry, you have not taken action?
Your Lordship, on the last occasion, Your Lordship, this honorable court was of the view that, Your Lordship, this read petition is not maintainable because the petitioners have no local standing in filing this read petition, Your Lordship.
not
May I
received
kindly
you.
see the order, Your Lordship?
Order dated 25th of August.
August 25.
August.
This matter was simply tagged along with item number 20, Your Lordship. Notice was also not issued, Your Lordship.
Second last paragraph. Madam.
You are not the complainant.
No.
No,
How
I'm
do you come to enforce?
since this both the petitioners are the members of the scheduled tribe, and
No,
they're
no.
yes,
You are not the complainant.
no,
Yes.
You need to have a locus to approach this court. Somebody has complained.
yes.
His
DC
complaint was successfully adjudicated in his favor. And the cancellation order itself is the subject matter of challenge in WPC 338 of 2022. At
yes.
best, we can tag this with 338, but
Yes.
your locus will be doubtful. What about the complainant? Why hasn't he come?
Complainant earlier it was Deputy Commissioner Tawang.
No, complainant.
Yes, complainant.
How can a deputy commissioner Tawang be the complainant? Somebody has complained regarding
Yes.
status.
Madam, I'll just clarify. Madam. In the year 2008, on the basis of an inquiry report of an executive magistrate, my scheduled trial certificate was cancelled by deputy commissioner. I put that inquiry report and the cancellation order in before this honorable court, challenging that in a writ petition. That writ petition was, my lord, in that writ petition, the matter was remanded back to the caste scrutiny committee
Yes.
for verifying my status in terms of the scheme laid down in the Kumari Madhuvi Pattem.
Now, after that, my lord, on the recommendation of a CBO, community-based organization, and a guideline of Government of India, the scrutiny committee came to a finding that I do not belong to scheduled tribe. Now, that particular, my lord, the order of the scrutiny committee has been put to challenge in
338.
338 on the ground that there has been violation of the procedure prescribed under.
That is okay, that you may have grounds, you may succeed in this ground, that's a different. How does he come into the picture? How does he come into the
That is what,
picture?
my lord, the honorable court is of a prima facie finding, has given a prima facie finding that they do not have a locus. Now.
Yes.
You can do one thing, you can file an implement in the challenge led by him, that's a different matter. Then your respect of defending the order or opposing his prayer, you might, the court might, but to institute a writ petition on your own and maintaining it will be difficult. You take instructions. Okay.
My lord, in item number 20, my lord, the community-based
20 is 338.
338.
Oh, both are connected. They have come together today.
Yes, my lord.
Okay, very good. Oh, 338 is there, yes.
May I, my lord?
Yes.
In 338, my lord, service in respect of respondent number 4 is still awaited.
Who is 4?
4 is the community-based organization on the basis of whose comment the.
Okay, you're not the community-based organization.
no,
You could have come.
No.
Your locus will be in doubt. They have not been served.
No, my lord. Therefore, I pray that I may be.
Thing you for whom?
Lordship, in item number 19, for the respondent number 6.
Who?
Although the notice has not been.
Who's 6?
6 is the petitioner in
I
338.
am. My ST was cancelled, Your Lordship.
And who are you?
Well, I'm the same person who has filed the WPC 338.
No, you're together or what?
Yes.
Oh. No, you're together and it's okay. No, we thought he's appearing for somebody else.
No.
Then it's okay. Would you like to file any affidavit, madam?
My lord, they have already filed.
Yes, we have filed in item
My
20.
lord, I may be allowed to take dusty service or respondent number 4. In the meantime, my lord, I will file my affidavit, rejoinder.
Okay. What is your name?
B. Padum.
B. Padum, huh? Heard Sri B. Padum, learned counsel for the petitioner in WPC 394 of 2025. Also heard your
RL Thungan.
RN?
RL Thungan.
Your name is not there.
Well, it's there, my lord. It's a cost list. Item number 20, my lord.
RL Thongan. Rinchen Dev.
RL, okay, RL Thungan. Learned counsel for the petitioner in WPC 338 of 2022. Full stop. This court has been apprised of the order dated 25/8/2025 passed in WPC 394 of 2025, wherein a question on the locus of the petitioner to maintain the present writ petition has been raised. So far as WPC 338 of 2022 is concerned, Sri Thungan, the learned counsel, has submitted that so far as that with regard to the aspect of service upon the respondent number 4 is concerned, the same is incomplete, and he prays for a liberty to serve the respondent number 4 by dusty. Full stop. Also heard Ms. Basar, the learned state counsel, who has submitted that affidavit in opposition has been filed. Considering the above, Sri Thungan, the learned counsel, is given liberty to serve the respondent number 4 by dusty, which is required to be routed, ROUTED, through the registry of this court. Full stop. In the notice accompanying the dusty, the next date fixed has to be clearly reflected. It is also required for the petitioner to file an affidavit before the next date as proof of such dusty service. List on this 3rd. List on 2nd of March. Rest not required. Okay. Is there any urgent matter? Mr. Lampu, any urgent matter? Otherwise, dates will be given. Madam will give dates.
Yes, ma'am.
Item number 21.
No, the rest you give dates, not required,
Okay,
unless it's very urgent. Which matter is yours?
25, 26.
Any urgency?
Since this is tender matter, my lord, I will see.
We'll have an early date today, we don't have.
Yes,
time.
Your Honor.
Mr. Atta, which matter?
25, 26.
Oh, this matter, same matter. You have a date of your convenience, maybe day after tomorrow, if you're comfortable.
My lord, let it be after third week. my lord.
After the next Monday?
After a week, yes.
Next Monday or next Tuesday? Monday, we may be slightly late.
Let it be on 13.
Next Tuesday.
13.
13.
12.
It'll be, next Tuesday is the 10th.
Oh, 10.
10th. Okay,
Fine.
and others?
Yes, my lord, in item number 24, since 2018 matter, so this may be on next
We'll have a-
Tuesday, my lord, next Tuesday.
Next
10.
Tuesday, okay, next Tuesday. Okay.
yes.